Welcome to Illinois Physical Therapy Ethics and Jurisprudence. Physical therapy practice in Illinois sits at the intersection of clinical science, regulatory obligation, and professional ethics. Every licensed physical therapist and physical therapist assistant in this state works within a framework of statutory requirements, administrative rules, and professional standards that together define not only what you may do clinically, but how you must conduct yourself across every dimension of professional life, from patient interactions and documentation to billing, supervision, and mandatory reporting. Mastery of this framework isn't optional. It's foundational to safe, lawful, and ethical practice. This 3-contact-hour course addresses that framework in detail. It begins with the structure and function of the Illinois Department of Financial and Professional Regulation, known as IDFPR, the agency vested with licensing and disciplinary authority over Illinois PTs and PTAs, and proceeds through the statutory and regulatory sources that define physical therapy practice. The Illinois Physical Therapy Act, codified at 225 ILCS 90, and the implementing administrative rules at 68 Illinois Administrative Code, Part 1340, will examine scope of practice, direct access, and telehealth regulations in depth, including the specific numeric thresholds and notification requirements that govern direct access practice and the licensure requirements that apply when PT services are delivered via remote technology. Supervision requirements for PTAs, aides, students, and license-pending applicants are covered alongside the documentation obligations that attach to each supervisory relationship. The continuing education requirements governing license renewal are presented with precision, including the 3-hour ethics and jurisprudence mandate that this course fulfills. The course's second major focus is professional ethics. Illinois PTs and PTAs are now governed by the 2026 APTA Code of Ethics for the physical therapy profession, which is the first unified code applying to both PTs and PTAs. This code was adopted by the American Physical Therapy Association House of Delegates on July 14, 2025, and became effective January 1, 2026. It introduces 9 ethical commitments with enforceable standards of conduct, addresses the ethical dimensions of artificial intelligence and other emerging technologies, and supersedes the separate 2020 PT Code and PTA standards of ethical conduct. We'll also walk through the realm individual process situation model of ethical decision-making, known as the RIPS model. Federal and Illinois fraud and abuse laws, including the False Claims Act, the Anti-Kickback Statute, and the Illinois Healthcare Workers Self-Referral Act, are examined in the context of billing integrity and referral relationships, with attention to the disciplinary consequences for Illinois licensees who violate these provisions. Throughout, the course grounds each topic in the public protection mission that the Illinois legislature expressly assigned to IDFPR and the Practice Act. This course is designed for physical therapists and physical therapist assistants professionals licensed or practicing in Illinois. Professionals taking this course will encounter content grounded in the Illinois Physical Therapy Act and the 2026 APTA Code of Ethics for the physical therapy profession, sources that apply directly to PT and PTA licensees. The ethical frameworks, including the RIPS model, federal fraud and abuse statutes, confidentiality obligations, and mandatory reporting requirements. Upon completion of this course, you'll be able to meet 7 learning objectives. First, identify the IDFPR regulatory framework governing physical therapy licensure and practice in Illinois. Second, describe the scope of practice for physical therapists and physical therapist assistants in Illinois. Third, explain the supervision requirements for PTAs, aides, and students under Illinois physical therapy law. Fourth, list the continuing education requirements for Illinois PT and PTA license renewal. Fifth, recognize the 4-step RIPS model of ethical decision-making in physical therapy practice. Sixth, define the enforceable standards of conduct in the 2026 APTA Code of Ethics for physical therapy. And seventh, state the key provisions of federal and Illinois fraud and abuse laws applicable to physical therapy practice. Let's move into Module 1, which covers the Illinois regulatory framework and licensure. Physical therapy in Illinois is governed by a detailed regulatory structure administered through the state's licensing authority, grounded in an express legislative mandate to protect the public, and carried out through a body of statutes, administrative rules, and disciplinary mechanisms. Understanding the architecture of this system, its institutional actors, primary legal sources, licensure requirements, and disciplinary framework is the essential foundation for competent and ethical Illinois PT and PTA practice. We'll begin with IDFPR, the Physical Therapy Licensing and Disciplinary Board, and the legislative intent behind physical therapy regulation in Illinois. The Illinois Department of Financial and Professional Regulation, or IDFPR, operating through its Division of Professional Regulation, is the state agency responsible for licensing and regulating physical therapists and physical therapist assistants in Illinois. IDFPR administers more than 200 regulated professions and occupations. For physical therapy, licensing and disciplinary authority is vested in the Secretary of IDFPR, who serves as the constitutional officer responsible for all final licensure and disciplinary determinations. The Secretary is advised by the Physical Therapy Licensing and Disciplinary Board, a 7-member advisory body appointed by the Secretary. Under the statute, 6 of the 7 board members must be actively engaged in the practice of physical therapy in Illinois for a minimum of 5 years preceding their appointment, and 1 member must be a member of the public who is not licensed under the Act. The board acts in an advisory capacity and doesn't issue binding orders. The Secretary retains sole authority to render final determinations. The board's advisory functions are substantial and consequential. Board members participate in the review of licensure applications, advise the Secretary on disciplinary matters, participate in informal disciplinary conferences with licensees under investigation, observe formal evidentiary hearings, and recommend policy positions on regulatory matters affecting PT and PTA practice in Illinois. The clinical composition of the board ensures that disciplinary assessments are informed by professional expertise and an understanding of clinical realities, rather than relying exclusively on generalist administrative judgment. This peer-informed structure reflects the legislature's recognition that assessments of clinical competence, appropriate scope of practice, and professional conduct in physical therapy require specialized knowledge that non-clinician administrators simply don't possess. IDFPR's regulatory authority is an expression of the state's police power, the constitutional authority of state government to enact laws protecting the health, safety, and welfare of its residents. The April 18, 2025 Illinois Governor's Office of Management and Budget Sunset Review recommended continuation of the Illinois Physical Therapy Act, citing 14,711 active PT licenses, 5,795 active PTA licenses, and 173 active continuing education sponsor licenses as of July 2024. The act is currently scheduled for repeal on January 1, 2031, under the Illinois Regulatory Sunset Act, subject to legislative reauthorization following a required Governor's Office of Management and Budget review. This sunset structure ensures periodic legislative scrutiny of whether the regulatory framework continues to serve its public protection purpose, and it means Illinois practitioners should monitor legislative developments affecting the structure and scope of their regulatory environment. The legislature's express intent under 225 ILCS 90, Section 0.05, is the protection of the public health, safety, and welfare through state administrative control, supervision, licensure, and regulation of the practice of physical therapy. The Act is to be liberally construed to promote the public interest, and that principle has direct practical consequences for practitioners and employers. Where a practitioner's conduct falls in a gray area not explicitly resolved by the Act or rules, whether a particular procedure is within PT scope or whether a supervisory arrangement meets the applicable standard, the interpretive default favors whichever reading is most protective of patients and the public, not the practitioner. This liberal construction principle isn't merely a philosophical orientation. It shapes how IDFPR investigators, prosecuting attorneys, and administrative law judges approach ambiguous disciplinary situations. Now let's look at the 2 primary legal sources that define physical therapy practice in Illinois: the Illinois Physical Therapy Act and the implementing administrative rules. The Illinois Physical Therapy Act, codified at 225 ILCS 90, was originally enacted in 1965 and has been amended numerous times since to reflect evolving clinical practice, healthcare delivery models, and legislative priorities. The Act is organized around the full life cycle of physical therapy practice. The definition and scope of physical therapy in Section 1, intramuscular manual therapy in Section 1.5, practice without a referral in Section 1.2, licensure requirements, continuing education, supervision, and disciplinary enforcement. Together, these provisions define what physical therapy is, who may practice it and under what conditions, the qualifications and renewal obligations of licensees, and what conduct constitutes a ground for discipline or civil penalty. The implementing administrative rules, found at 68 Illinois Administrative Code Part 1340, were promulgated by IDFPR pursuant to the rulemaking authority granted by the Act, and they provide the operational specificity that the Act's broader statutory language requires. Part 1340 addresses initial licensure standards, endorsement criteria, continuing education requirements, including the 3-hour ethics and jurisprudence mandate at Section 1340.61, supervision standards for PTAs and aides, and the prerequisites for intramuscular manual therapy at Section 1340.75. Together, the Act and Part 1340 constitute the primary source of regulatory obligation for every Illinois PT and PTA. Violations of either the Act or the rules create independent grounds for discipline. The Act has been substantially amended 4 times since 2018, and these amendments matter for every Illinois practitioner. Public Act 100-897, effective August 16, 2018, enacted the direct access provisions at 225 ILCS 90 Section 1.2 that authorize PTs to evaluate and treat patients without a referring provider's order, subject to notification and re-referral requirements. Public Act 103-849, effective January 1, 2025, codified standards for telehealth delivery of PT services, establishing licensure requirements and patient rights provisions for remote care. Public Act 104-0411, effective August 15, 2025, materially amended the telehealth provisions at 225 ILCS 90, Section 1.3, to remove pre-2025 restrictions on initial physical therapy evaluations via telehealth without a referral. And Public Act 104-154, effective January 1, 2026, further amended Section 17, which covers disciplinary grounds, and Section 1.2, which covers direct access, reflecting continued legislative refinement of the framework. The bottom line is that Illinois practitioners must monitor statutory developments actively. The Practice Act has changed materially multiple times within the preceding decade, and ignorance of amendments is not a defense to disciplinary exposure. Title protection is among the Act's most practically significant consumer protection provisions. The titles physical therapist assistant, PT, DPT for Doctor of Physical Therapy, MPT for Master of Physical Therapy, RPT for Registered Physical Therapist, LPT for Licensed Physical Therapist, PTA, and any related abbreviations are reserved exclusively for licensed practitioners. Unauthorized use of these titles by an unlicensed individual constitutes a Class A misdemeanor for a first offense and a Class 4 felony for any subsequent offense. The civil penalty for unlicensed practice of physical therapy is up to $10,000 per offense. These graduated penalties reflect the legislature's assessment that unlicensed practice poses serious risks to patient safety and that nominal enforcement consequences wouldn't serve as a sufficient deterrent. Let's move to Section 3 of Module 1, which covers licensure requirements for both PT and PTA pathways, beginning with education and examination. Illinois requires that PT licensure candidates graduate from a professional program accredited by the Commission on Accreditation in Physical Therapy Education, known as CAPTE, at the doctoral or DPT level, or for foreign-educated applicants, from an equivalent program as determined by an IDFPR-recognized credentialing evaluation service, and pass the National Physical Therapy Examination, or NPTE, administered by the Federation of State Boards of Physical Therapy, known as FSBPT. For PTA candidates, CAPTE accreditation is required at the associate degree level. CAPTE accreditation provides assurance that an education program meets nationally recognized standards for curriculum content, clinical training, faculty qualifications, and student outcomes, establishing a quality baseline independent of individual candidate performance. The NPTE for PTs consists of 225 multiple-choice questions delivered in 5 sections of 45 questions each, with a 5-hour testing time, administered at Prometric testing centers nationwide. The NPTE for PTAs consists of 180 multiple-choice questions delivered in 4 sections of 45 questions each, with a 4-hour testing time, structured to assess entry-level clinical competence in the PTA role. Both examinations are periodically revised by FSBPT to reflect current clinical practice patterns, as identified through formal practice analyses conducted regularly across the profession. Passage of the NPTE establishes the minimum competency threshold for entry into practice. It's a floor, not a ceiling. The ongoing professional development obligations of licensure, including continuing education requirements and adherence to the APTA Code of Ethics, reflect the understanding that competence must be actively maintained and developed throughout a practitioner's career. Illinois doesn't currently administer a separate state jurisprudence examination as a condition of initial licensure, in contrast to a number of states that require passage of a state-specific law examination. Candidates do a firm understanding of mandated reporter obligations and other Illinois-specific professional requirements at the time of licensure application. The continuing education requirement for ethics and jurisprudence content, which we'll address in detail in Module 4, serves among other purposes as an ongoing mechanism for ensuring that practicing licensees maintain current knowledge of the regulatory and ethical obligations governing their practice. Now let's discuss license pending practice. Illinois permits applicants who have completed an approved education program and filed a complete application for licensure to engage in supervised clinical practice as license pending applicants while awaiting NPTE results and license issuance. License pending applicants must practice under the on-site supervision of a licensed PT, meaning the supervising PT must be physically present at the facility or premises where the license pending applicant is practicing. This on-site standard is more stringent than the general supervision standard applicable to licensed PTAs in most clinical contexts, reflecting the heightened oversight deemed appropriate for individuals whose entry-level competence hasn't yet been established through examination. License pending status terminates upon receipt of NPTE results. An applicant who fails the examination must immediately cease practice, and continued practice following notification of failure constitutes unlicensed practice subject to civil penalty. Moving on to endorsement licensure and the Physical Therapy Compact. Illinois issues licenses by endorsement to applicants who hold an active, unencumbered license in another U.S. jurisdiction with licensure requirements substantially equivalent to those of Illinois, subject to verification of licensure status, review of disciplinary history, payment of applicable fees, and any additional requirements specified by IDFPR. Endorsement provides a streamlined pathway for practitioners relocating from other states or establishing multi-state practice, but it isn't automatic. IDFPR reviews each applicant's background individually, including any prior disciplinary history in the issuing jurisdiction. Here's a point that comes up often. Illinois has not joined the Physical Therapy Compact as of 2026, despite multiple legislative attempts, including Senate Bill 1699 and House Bill 4593, in the 103rd Illinois General Assembly, neither of which advanced past the Rules Committee. The PT Compact is an interstate agreement that permits eligible PTs and PTAs in member states to obtain what are called compact privileges, allowing practice in other member states without obtaining full licensure in each state. As of 2026, the compact has been enacted by approximately 40 jurisdictions, with 37 states and the District of Columbia actively issuing compact privileges. Illinois is not among them. The practical consequences are significant. Illinois licensees can't rely on the compact to practice in member states and must pursue individual endorsement applications in each desired state. Out-of-state PT compact privilege holders can't treat Illinois patients, including via telehealth, based on their compact privileges and must obtain full Illinois endorsement licensure to do so. Illinois practitioners and their employers should monitor compact membership developments as they may materially affect multi-state practice planning. Let's shift to Section 4, which covers license renewal, expiration, and the disciplinary complaint process. Under 225 ILCS 90 and 68 Illinois Administrative Code, Part 1340, PT licenses expire and must be renewed on September 30 of even-numbered years, and PTA licenses expire and must be renewed on September 30 of odd-numbered years. The biennial, staggered cycle structure allows IDFPR to administer the renewal and continuing education audit process in manageable cohorts. The 24-month period immediately preceding the license expiration date is the pre-renewal period, during which the applicable continuing education requirement must be fulfilled, 40 hours for PTs and 20 hours for PTAs. A first renewal exemption applies. Licensees aren't required to satisfy the continuing education requirement for the first renewal following original licensure, providing newly licensed practitioners a grace period before the continuing education obligation commences. Practicing on an expired license constitutes unlicensed practice under the Act and subjects the practitioner to civil penalty of up to $10,000 per offense. This exposure arises regardless of the practitioner's intent. The expiration of the license creates the unlicensed practice condition independently of whether the practitioner knew the license had lapsed or intended to renew. Employers, staffing agencies, and healthcare organizations therefore have an organizational interest, and in many cases an independent legal obligation, to maintain systems that track PT and PTA license renewal status and prevent inadvertent lapsed license practice within their facilities. Now let's walk through the IDFPR disciplinary complaint process. Complaints against Illinois PT and PTA licensees are filed with the IDFPR Complaint Intake Unit. A complaint may originate from any source: a patient or family member, a competing practitioner or employer, a payer or insurer, another state or federal regulatory body, the news media, or IDFPR itself. Malpractice settlements are automatically reported to IDFPR and trigger an internal notice, ensuring that civil liability outcomes with potential disciplinary implications receive regulatory attention. Under 20 ILCS 2105, Section 2105-117, all information collected by IDFPR during examination or investigation of a licensee is confidential and can't be publicly disclosed except to law enforcement, to other regulatory bodies with an appropriate interest, or pursuant to a lawful subpoena. This confidentiality provision serves dual purposes. It protects the integrity of ongoing investigations and safeguards the reputational interests of licensees who are under investigation, but against whom no disciplinary action has yet been taken. The standard disciplinary process unfolds in 5 stages. At the intake stage, the Complaint Intake Unit reviews the allegations. If the facts as alleged would, if true, constitute a violation of the Act or rules, an investigation is opened. During the investigation stage, an IDFPR investigator obtains and reviews clinical records, employment documents, billing records, and other relevant materials, interviews witnesses, and refers the matter to the Health-Related Prosecution Unit if violations appear substantiated. At the informal disciplinary conference stage, the licensee, who has the right to representation by counsel throughout the process, meets with an IDFPR prosecuting attorney and one or more board members to discuss the evidence and explore settlement. There's no administrative law judge and no formal transcript at this stage. The vast majority of IDFPR disciplinary matters, more than 90% across all regulated professions in a typical year, are resolved at the informal conference stage through a negotiated consent order or stipulation of facts and recommendation for settlement. If the matter doesn't resolve, a formal complaint is filed and the case proceeds to a formal evidentiary hearing before an administrative law judge with board members present. Witnesses, including expert witnesses, may testify, and the administrative law judge's findings of fact, conclusions of law, and recommendations are forwarded to the board for its recommendation to the Secretary. The Secretary issues the final disciplinary order, and results are published in the IDFPR monthly disciplinary reports accessible to the public. Fewer than 200 formal evidentiary hearings occur in a typical year across all IDFPR-regulated professions, while the Department imposes discipline on approximately 3,000 licensees annually across all regulated professions. That ratio highlights both the frequency of disciplinary activity and the strong settlement orientation of the process. Now let's examine the grounds for discipline under Section 17 of the Illinois Physical Therapy Act. Section 17, codified at 225 ILCS 90 Section 17, is the Act's central enforcement provision and enumerates 26 specific grounds upon which the Department may refuse to issue or renew a license, or may revoke, suspend, place on probation, reprimand, or otherwise discipline a PT or PTA licensee. Fines of up to $5,000 per violation may be imposed in addition to or in lieu of other disciplinary action. These grounds, designated A through Z, collectively cover the full range of professional misconduct and regulatory noncompliance that can arise in physical therapy practice, and any single ground, standing alone or in combination with others, may support disciplinary action. Ground A encompasses material misstatements and misleading, deceptive, untrue, or fraudulent representations in connection with professional practice. Ground B covers violations of the Act or the implementing administrative rules, making any failure to comply with the requirements of 225 ILCS 90 or 68 Illinois Administrative Code, Part 1340, a disciplinary basis. Ground C applies upon conviction of any crime that is a felony, a misdemeanor with an essential element of dishonesty, or a crime directly related to PT practice. The term conviction expressly includes a finding or verdict of guilty, an admission of guilt, or a nolo contendere plea. Ground D addresses misrepresentation to obtain a license and violations of advertising rules. This ground is particularly relevant to the prohibition on misrepresenting dry needling as acupuncture, which we'll discuss in Module 2. Ground D permits discipline based on a pattern demonstrating incapacity or incompetency, even where no single incident is independently sufficient to warrant action. Ground F applies to aiding or assisting another in violations of the Act or rules. And Ground G covers failing to respond in writing within 60 days to a written request from the department. Ground H is among the broadest and most frequently invoked provisions in the Act. It prohibits dishonorable, unethical, or unprofessional conduct of a character likely to deceive, defraud, or harm the public, including any departure from or failure to conform to the minimal standards of acceptable and prevailing physical therapy practice. Here's the thing. Under this ground, no actual injury to a patient need be established. The potential for harm to the public is sufficient. This ground extends to matters of ethical and professional conduct not explicitly addressed by other enumerated grounds, operating as a residual provision that captures the full range of conduct incompatible with professional practice. Ground Y covers unlawful distribution or conversion of drugs or narcotics. Ground J addresses habitual or excessive use of or addiction to alcohol, narcotics, stimulants, or other chemical agents resulting in the inability to practice with reasonable judgment, skill, or safety. Ground K applies upon discipline by another state, territory, or country. Ground L prohibits fee splitting and kickbacks, with stated exceptions for partnerships, professional service corporations, and bona fide employment arrangements. Ground M covers probation violations. Ground N addresses patient abandonment. Ground O reaches willful failure to report suspected child abuse or neglect as required by the Abused and Neglected Child Reporting Act. Ground P addresses willful failure to report suspected elder abuse or neglect. The statutory cross-reference in Section 17, Ground P, still names the Elder Abuse Reporting Act, which has since been renamed and is now codified as the Adult Protective Services Act at 320 ILCS 20. Ground Q covers physical illness, including deterioration through aging or loss of motor skill, resulting in inability to practice with reasonable judgment, skill, or safety. Ground R prohibits use of the physical therapist title or abbreviations without a valid PT license. And Ground S prohibits analogous unauthorized use of the PTA title. Continuing with the remaining grounds, Ground T covers willful violation of Illinois law relating to the practice of abortion. Ground U addresses continued practice with a known infectious, communicable, or contagious disease. Ground V reaches treating ailments other than by physical therapy, as defined in the Act, or treating ailments as a PT in violation of the direct access provisions of Section 1.2. Ground W applies when the licensee has been named as the perpetrator in an indicated Department of Children and Family Services report, and the evidence establishes by a clear and convincing standard that the licensee caused a child to be abused or neglected. Ground X specifically prohibits a PTA from interpreting referrals, performing evaluations, or making major plan of care modifications, all of which are functions reserved for licensed PTs. Ground Y requires that a PTA and supervising PT maintain continued contact and periodic personal supervision and instruction, with failure to do so being an independent disciplinary ground. And Ground Z incorporates violations of the Healthcare Workers Self-Referral Act as a basis for PT and PTA license discipline, linking the referral relationship requirements of that act directly into the PT regulatory framework. Two additional automatic suspension provisions apply independently of the complaint process. Involuntary admission to a mental health facility triggers automatic license suspension, and failure to file required state tax returns or pay state taxes can lead to refusal or suspension of licensure. To close Module 1, let me emphasize why GroundH's competence and conduct standard matters so much. It intersects directly with the professional ethics framework we'll examine later in this course. IDFPR investigates substandard care complaints under this provision, and a PT may be legally authorized to perform a clinical technique under the Act, yet still face discipline if the PT lacks the clinical competence, meaning the knowledge, skill, and judgment, to perform it safely and effectively in that patient's specific circumstances. The 2026 APTA Code of Ethics Standard 8.1 codifies this principle at the professional level, requiring physical therapists to recognize and practice within the limits of their skills and competence, and to refer a patient or client to another healthcare professional when it is in the best interests of the patient or client. The regulatory standard in Section 17 GroundH and the professional obligation in Code Standard 8.1 operate in concert, establishing both a licensure floor and a professional obligation that the same conduct must satisfy from two independent directions. Welcome to Module 2, where we turn our attention to scope of practice, direct access, and telehealth. The statutory and administrative definition of physical therapy practice in Illinois establishes the clinical and legal boundaries within which every PT and PTA must operate. In this module, we'll examine those boundaries in detail. We'll cover the statutory definition of physical therapy and its enumerated scope limitations, the specific training prerequisites for dry needling as an advanced clinical skill, the direct access provisions that permit PT practice without a physician referral, and the precise conditions that accompany that authority, and the Telehealth framework enacted effective January 1, 2025, that governs remote delivery of PT services. Departure from any of these provisions creates disciplinary exposure and, more fundamentally, may compromise patient safety. Let's begin with the statutory definition and scope of physical therapy in Illinois. The definition of physical therapy under Illinois law is found at 225 ILCS 90, Section 1, and establishes the outer boundary of what licensed PTs and PTAs may lawfully do under their Illinois licenses. Under the statute, physical therapy means the evaluation or treatment of a person by the use of effective properties of physical measures including heat, cold, light, water, radiant energy, electricity, sound, and air, therapeutic massage, exercise and mobilization, and rehabilitative procedures for preventing, correcting, or alleviating physical or mental disability. That's a broad functional definition, and it encompasses the wide range of physical modalities, assessment tools, and therapeutic techniques that constitute contemporary PT practice. Within this definitional framework, the Act expressly enumerates specific activities that fall within the scope of licensed PT practice. These include the performance of specialized tests and measurements, the administration of specialized treatment procedures, the interpretation of referrals from physicians, dentists, advanced practice registered nurses, physician assistants, and podiatric physicians, the establishment and modification of physical therapy treatment programs, the supervision and teaching of physical therapy, the performance of dry needling in accordance with Section 1.5, and the administration of topical medication used in generally accepted PT procedures when prescribed by the patient's physician, DPM, APRN, PA, or dentist, or used pursuant to that practitioner's orders. Exceeding these enumerated authorities, whether by performing procedures outside the statutory definition or by engaging in activities the Act expressly reserves to other professions, constitutes a violation of the Act under Section 17(1)(b) and may constitute unprofessional conduct under Section 17(1)(h). Now let's discuss the critical scope limitations that every Illinois PT and PTA must internalize. Physical therapy practice in Illinois expressly does not include radiology, electrosurgery, chiropractic technique, or the determination of a differential diagnosis. The differential diagnosis exclusion warrants careful contextual understanding. The Act expressly provides that this limitation shall not in any manner limit a physical therapist's evaluation pursuant to license, meaning that the evaluation function, the systematic clinical assessment of the patient's presentation, remains fully within PT scope, but rendering a medical differential diagnosis in the physician's sense is not within PT authority. So what does that mean in practice? Illinois PTs evaluate patients, form physical therapy diagnoses grounded in movement system impairments, and develop clinical prognoses within the scope of physical therapy. They don't render medical differential diagnoses. Practitioners who characterize their evaluative findings in ways implying medical diagnostic authority beyond PT scope assume disciplinary and civil liability risk. Turning to the topic of topical medications, the statutory topical medication authority is strictly circumscribed. Illinois PTs may administer topical medication used in generally accepted PT procedures, but only when that medication has been prescribed by or its administration ordered by the patient's physician, DPM, APRN, PA, or dentist. The authority is administrative, not prescriptive. A PT who independently selects and administers a topical medication without the required prescriber order exceeds the scope of PT practice and may face discipline under multiple Section 17 grounds. As we discussed in Module 1, the Act's title protection provisions reserve the titles physical therapist assistant, PT, PTA, and all related professional abbreviations exclusively for licensed Illinois practitioners, with criminal and civil penalties for unauthorized use. In the scope of practice context, title protection serves a distinct consumer protection function. Patients and payers rely on these protected titles as assurances of verified competence and regulatory accountability. Allowing unlicensed individuals to use them would fundamentally undermine the public protection purpose of the licensing system. Now let's move to Section 2, which covers dry needling and intramuscular manual therapy. Illinois addressed the practice of dry needling through explicit statutory authorization in 225 ILCS 90, Section 1.5, accompanied by detailed educational prerequisites codified in the implementing rule at 68 Illinois Administrative Code Section 1340.75. This approach, a conditional authorization contingent on demonstrated prerequisite training, reflects a legislative balancing of the therapeutic value of dry needling as a PT modality against the patient safety risks inherent in performing needling techniques without adequate preparation. Under Illinois law, dry needling is defined as an advanced needling skill or technique limited to the treatment of myofascial pain using a single-use, single-insertion, sterile filiform needle, without the use of heat, cold, or any other added modality or medication that is inserted into the skin or underlying tissues to stimulate trigger points. The Illinois definition applies theory based only upon Western medical concepts, requires examination and diagnosis, and treats specific anatomic entities selected according to physical signs. The statute expressly excludes from this authorization the teaching or application of acupuncture, as described by stimulation of auricular points, distal points, non-local points, needle retention, application of retained electric stimulation leads, or other traditional acupuncture theory. Dry needling, as authorized under Illinois law, is a categorically distinct technique from acupuncture, and the statute enforces that distinction rigorously in both its definitional provisions and its misrepresentation prohibitions. Let's now walk through the 5-element prerequisite sequence that must be completed before a PT or PTA may perform dry needling or intramuscular manual therapy in Illinois. All 5 of the following prerequisite requirements must be satisfied in their entirety. First, the practitioner must have completed at least 50 hours of college-level instruction from an accredited institution, covering the musculoskeletal and neuromuscular system, anatomical bases of pain mechanisms, chronic and referred pain, myofascial trigger point theory, and universal precautions. Second, the practitioner must complete at least 30 hours of didactic coursework specific to the theory and practice of dry needling. Third, the practitioner must successfully complete at least 54 practicum hours covering intramuscular manual therapy technique, indications and contraindications, documentation, management of adverse effects, practical psychomotor competency, and the OSHA, or Occupational Safety and Health Administration, bloodborne pathogen standard. This practicum includes an initial module of at least 27 hours, with the remaining practicum hours to be completed within a 24-month window. Fourth, the practitioner must complete at least 200 patient treatment sessions under the applicable supervision standard. For PTs, this means general supervision. For PTAs, this means direct line-of-sight supervision by a PT who has independently satisfied all 5 prerequisite requirements. That's a big deal because the direct line-of-sight supervision requirement for PTAs performing dry needling is notably more restrictive than the general supervision standard that governs most other PTA clinical activities, reflecting the advanced and higher-risk nature of the technique. And fifth, the practitioner must successfully pass a division-approved competency examination demonstrating proficiency in dry needling. There's an additional timing restriction to be aware of. A newly licensed PT may not perform intramuscular manual therapy for at least 1 year from the date of initial PT licensure, unless the PT completed all 5 prerequisite elements as part of pre-licensure educational training. This 1-year post-licensure restriction reflects the legislature's judgment that the technique demands a foundation of general clinical experience that new graduates, whatever their academic preparation, haven't yet had the opportunity to develop through independent license practice. Now, regarding the misrepresentation prohibition and disciplinary exposure. The Act expressly prohibits a PT or PTA from advertising, describing to patients or the public, or otherwise representing that dry needling is acupuncture. Similarly, no PT or PTA may represent that they practice acupuncture unless separately licensed under the Illinois Acupuncture Practice Act at 225 ILCS 2. This prohibition extends to all communication channels, including oral representations during patient encounters, written patient education materials, website content, social media, and any other medium through which the practitioner communicates with patients or the public. A PT who performs techniques consistent with acupuncture theory under the label dry needling, or who represents to a patient that dry needling and acupuncture are the same, violates the Act under multiple provisions. Misrepresentation in connection with professional practice is a ground for discipline under Section 17(1)d, and the same conduct may also constitute unprofessional conduct under Section 17(1)h. These disciplinary exposures aren't theoretical. The IDFPR complaint process is open to any member of the public, including patients who believe they were misled about the nature of their treatment. Let's turn to Section 3, which addresses direct access, including its requirements and limitations. Illinois authorized physical therapists to evaluate and treat patients without a referring healthcare professional's order, effective August 16, 2018, under Public Act 100-897, with further refinements through Public Act 104-154, effective January 1, 2026. The operative statutory provision is 225 ILCS 90, Section 1.2, which authorizes a PT to provide physical therapy services to a patient with or without a referral from a healthcare professional, subject to specific notification, communication, and re-referral requirements. Direct access doesn't expand the substantive scope of physical therapy practice. All scope limitations established by Section 1, including the prohibition on rendering a differential diagnosis, continue to apply in the direct access context. Direct access is an authorization to initiate PT care without a prior referral order. It's not a grant of expanded clinical authority over what physical therapists may assess or treat. The availability of direct access has meaningfully shifted the relationship between physical therapists and other healthcare providers, enabling patients to seek PT evaluation and treatment without the delay and cost of obtaining a prior physician's referral. It simultaneously places greater demands on the PT's clinical judgment. The PT must assess not only whether the patient's presentation falls within PT scope, but also whether the patient's overall health status, response to treatment, and progress over time require referral to another provider, including at the mandatory re-referral thresholds we'll discuss shortly. Let's look at the notification obligation under direct access. When a PT provides physical therapy services to a patient without a referral, the PT must notify the patient's treating healthcare professional within 5 business days after the patient's first visit that the patient is receiving physical therapy services. This notification requirement serves a care coordination function essential to patient safety. The patient's treating provider must be aware of the PT episode of care in order to integrate that information into the broader management of the patient's health and to respond if information about the patient's status warrants clinical action. An exception applies when the PT services are fitness or wellness services and the patient doesn't present with a qualifying ailment or injury. Next is the chronic disease communication obligation. A PT providing direct access services to a patient who has been diagnosed by a healthcare professional with a chronic disease that may benefit from physical therapy must communicate at least monthly with the patient's treating healthcare professional throughout the course of treatment. This ongoing communication obligation, in addition to the initial 5-business-day notification, reflects the legislature's recognition that patients with chronic conditions benefit from coordinated, interdisciplinary management that includes regular information sharing between the PT and the primary treating provider. A parallel monthly communication requirement applies even when the patient has a referral. Under Section 1.2b10, a PT treating a referred patient with a chronic disease diagnosis must communicate at least monthly with the referring healthcare professional, consistent with the plan of care. This parallel provision ensures that the monthly communication standard applies to chronic disease patients regardless of whether their PT episode began with or without a referral. The implementing rule at 68 Illinois Administrative Code 1340.85b carves out a specific exemption from the monthly chronic disease communication requirement. It doesn't apply to services delivered by a physical therapist as part of the Illinois Early Intervention or EI program, an Individualized Education Plan or IEP, or a federal 504 plan under 29 U.S.C. 701 through a school system. School-based PTs operating under EI, IEP, or 504 frameworks should document the basis for the exemption in the clinical record, but aren't bound by the monthly communication obligation that otherwise applies to chronic disease direct access patients. Now we come to one of the most important direct access provisions, the re-referral obligation, commonly known as the 10-visit, 15-business-day rule. Illinois imposes an affirmative re-referral obligation on PTs providing direct access services in 3 specified circumstances. First, if the patient doesn't demonstrate measurable or functional improvement after 10 visits or 15 business days, whichever occurs first, and doesn't demonstrate continued improvement thereafter, the PT must refer the patient to a healthcare professional, either the patient's healthcare professional of record or one of the patient's choosing. The Act provides no numeric threshold for measurable or functional improvement. The clinical determination rests entirely on the PT's documented professional judgment. When improvement is absent or has plateaued beyond the threshold, the mandatory referral obligation is triggered. Second, a PT must refer a patient who was treated under direct access without an established chronic disease diagnosis and who returns for services for the same or similar condition after 30 calendar days of having been discharged. And third, the PT must refer if the patient's condition is determined to be beyond the PT's scope of practice. There are also 2 condition-specific limitations that govern direct access practice. The first involves wound debridement. Wound debridement services may be provided by a PT without a traditional referral only when the PT has obtained written authorization from a healthcare professional before providing those services. The written authorization requirement reflects the complexity of wound care clinical decision-making and the need for physician or other provider involvement in authorizing wound debridement interventions in the direct access context. The second involves temporomandibular disorder, or TMD. The Act requires that when the patient's presentation indicates possible TMD, the PT must promptly consult and collaborate with the appropriate healthcare professional so that a formal diagnosis can be made. This consultation obligation reflects both the diagnostic complexity of TMD and the clinical overlap between dental and PT roles in its assessment and management. PTs providing direct access services in Illinois bear documentation obligations that correspond to each of the statutory requirements. These include documentation of the 5-business-day notification to the treating healthcare professional, documentation of monthly chronic disease communications and their substantive content, documentation of the 10-visit or 15-business-day re-referral threshold and any referrals made pursuant to it, documentation of wound debridement written authorization, and documentation of TMD consultation, or the clinical basis for concluding that TMD indicators were not present. These documentation obligations aren't administrative formalities. They create an evidentiary record that demonstrates compliance with direct access requirements, and that will be the primary evidence in any disciplinary proceeding arising from a direct access complaint. A PT's failure to comply with the notification, communication, re-referral, wound debridement, or TMD consultation provisions of Section 1.2 constitutes both a violation of the Act under Section 17(1)B and a potential departure from the minimal standards of acceptable and prevailing PT practice under Section 17(1)H. Let's move to Section 4, which covers telehealth in Illinois physical therapy practice. The growth of telehealth as a modality for PT service delivery accelerated substantially in the years following the COVID-19 public health emergency, and Illinois responded by codifying a permanent statutory framework for telehealth delivery of PT services through Public Act 103-849, effective January 1, 2025. Prior to this enactment, telehealth PT operated under emergency orders and ad hoc regulatory guidance. The 2025 amendments established durable rules that define how telehealth PT can be delivered safely and ethically while protecting patient rights and maintaining the same regulatory accountability that applies to in-person care. Less than 8 months later, Public Act 104-0411, also known as SB 2153, signed by Governor Pritzker and effective August 15, 2025, materially amended 225 ILCS 90, Section 1.3, to remove several restrictions imposed by the original framework. As amended, initial physical therapy evaluations without a referral or established diagnosis may now be performed by a licensed physical therapist via telehealth, when the physical therapist determines that an in-person examination is not required based on clinical judgment and the applicable standard of care, replacing the prior rule that limited telehealth initial evaluations to documented hardship situations. The amended statute also clarifies that a physical therapist providing telehealth must have the capacity to provide in-person care within Illinois or be able to refer the patient to in-person care within Illinois, and that the standard of care for a patient receiving physical therapy through telehealth is equal to the standard of care for in-person care. The framing in this module reflects the post-SB 2153 statute as currently in effect. Under the telehealth provisions, any PT or PTA who treats a patient located in Illinois via telehealth must hold an Illinois PT or PTA license or otherwise be authorized to practice physical therapy in Illinois. This requirement applies regardless of where the PT or PTA is physically located at the time of the telehealth encounter. A PT licensed only in another state who delivers telehealth services to an Illinois-located patient is engaged in unlicensed practice in Illinois and is subject to the full range of civil penalties under the Act. This rule reflects the core patient protection rationale underlying all licensure requirements. Illinois patients receiving telehealth-delivered PT services are entitled to the same assurance of regulatory oversight and recourse through the IDFPR complaint process as patients receiving care in person. Now for patient rights, in-person capacity, and PTA supervision in the telehealth context. The telehealth framework incorporates provisions designed to ensure that remote delivery of PT services doesn't diminish the quality or accessibility of care. The treating PT must have the capacity to provide or refer the patient to in-person physical therapy care within Illinois. A PT who can offer only telehealth services and who lacks any capacity to connect patients with in-person care when clinically indicated doesn't satisfy this requirement. A patient has the right to request and receive in-person care at any point during the course of treatment. Conversely, a PT or PTA may require an in-person visit when clinical circumstances make telehealth delivery inappropriate. These provisions prevent telehealth from becoming a mechanism by which patients in need of in-person clinical contact are denied that access. The 2025 telehealth amendments further specify that a PTA who provides telehealth services under the general supervision of a physical therapist while treating a patient located in Illinois must be licensed or authorized to practice physical therapy in Illinois. This provision prevents circumvention of Illinois licensure requirements through supervision arrangements in which an out-of-state PTA provides telehealth services to Illinois patients under a supervising Illinois licensed PT. Both the supervising PT and the supervised PTA must independently satisfy Illinois licensure requirements. All laws regarding professional responsibility, unprofessional conduct, and standards of practice that apply to a provider under their Illinois license apply with equal force during telehealth service delivery. All laws regarding confidentiality of healthcare information and patient rights to medical information, including HIPAA and the Illinois Mental Health and Developmental Disabilities Confidentiality Act, or MHD-DCA, at 740 ILCS 110, apply fully to telehealth encounters. This equivalence principle is foundational to the regulatory framework. Telehealth isn't a regulatory gray zone, and PTs and PTAs who assume that remote delivery creates any relaxation of professional obligations expose themselves to disciplinary liability under the same standards that apply in the clinical setting. The direct access requirements of 225 ILCS 90, Section 1.2 apply in full to telehealth-delivered PT services provided without a referral. A PT providing telehealth evaluation and treatment under direct access must comply with the 5 business day notification obligation, the monthly chronic disease communication requirement, the 10 visit or 15 business day re-referral threshold, the 30 calendar day return after discharge re-referral rule, the wound debridement written authorization requirement, and the TMD consultation obligation, precisely as in in-person direct access practice. The telehealth modality doesn't alter, suspend, or relax any of these requirements. Finally, let's address the implications of Illinois' relationship with the PT Compact for telehealth practice. As we established in Module 1, Illinois has not joined the Physical Therapy Compact as of 2026, despite legislative attempts including Senate Bill 1699 and House Bill 4593 in the 103rd General Assembly. For telehealth practice, the consequence is direct. PT Compact privileges from member states don't permit treatment of Illinois-located patients, whether in person or via telehealth. Out-of-state practitioners holding compact privileges in their home state can't rely on those privileges to provide telehealth services to patients located in Illinois. Full Illinois endorsement licensure is required. Conversely, an Illinois licensed PT who wishes to provide telehealth services to patients located in other states must investigate and comply with the licensure or authorization requirements of each destination state individually, whether through the compact, if that state is a member and the practitioner is eligible, or through traditional endorsement processes if it is not. The practical significance of Illinois' compact non-membership extends to multi-state telehealth platforms, employer telehealth programs, and interstate care coordination arrangements that depend on reciprocal practice authority. Illinois practitioners and their organizations should obtain current, state-specific licensure guidance for every jurisdiction in which their patients may be located. Welcome to Module 3, Supervision Requirements and Documentation Standards. This module covers the 2 core operational obligations that govern every Illinois PT and PTA in daily practice: supervision requirements and documentation standards. Supervision rules define who must oversee whom and how closely, with standards that differ for PTAs, aides, students, and license-pending applicants, plus a more restrictive standard for the high-risk context of dry needling. Documentation rules define what every clinical encounter must produce, by whom, and for how long. And here's something worth knowing. Inadequate documentation is itself an independent basis for disciplinary action under Section 17(1)(h). Together, these requirements put the public protection mandate of the Illinois Physical Therapy Act into practice at the point-of-care level. Let's start with PTA supervision requirements. Under the Illinois Physical Therapy Act and the implementing administrative rules in 68 Illinois Administrative Code. Part 1340, physical therapist assistants are authorized to assist in implementing a physical therapy treatment program as established by the supervising physical therapist. That assistive role is bounded by express statutory and regulatory limitations. A PTA's patient care activities shall not include the interpretation of referrals, evaluation procedures, or the planning or major modification of patient programs. These restrictions reflect a foundational principle of Illinois PT regulation, that clinical assessment, program design, and plan of care authority belong exclusively to the licensed physical therapist regardless of practice setting. The supervisory standard for PTAs under Illinois law is general supervision, and that's a term of art carrying specific affirmative obligations for the supervising PT. General supervision doesn't mean mere availability or passive oversight. The supervising PT must maintain continual contact with the physical therapist assistant, including periodic personal supervision and instruction to ensure the safety and welfare of the patient. This continual contact requirement imposes an ongoing communicative obligation. The supervising PT must be reachable, must actively monitor PTA performance, and must conduct in-person supervisory visits at intervals sufficient to ensure patient safety and treatment program integrity. The frequency and nature of those in-person visits aren't specified by bright-line numerical standards in the statute. Instead, adequacy is assessed in light of the complexity of the patient population, the PTA's experience and competency, and the clinical demands of the practice setting. The consequences of failing to meet the general supervision standard are expressly spelled out in Section 17 of the Practice Act. Permitting a PTA to interpret referrals, perform evaluation procedures, or independently plan or make major modifications to a patient program constitutes a Section 17(1)(x) ground for discipline. That ground applies both to the PTA who performs the unauthorized function and to the supervising PT who permits or fails to prevent it. Separately, a failure by either the supervising PT or the PTA to maintain the continual contact required by the Act is a Section 17(1)(y) disciplinary ground. Both grounds may result in fines of up to $5,000 per violation, suspension or revocation of licensure, and public reporting on IDFPR's disciplinary role. The dual-party exposure here is significant. Both the PTA and the supervisory PT are held accountable, reflecting the legislature's intent to create a system of shared responsibility where neither party can disclaim accountability for breakdowns in the supervisory relationship. The 2026 APTA Code of Ethics, which we'll introduce in detail in Module 6, reinforces these statutory obligations through its Commitment 7 on direction and supervision. Standard 7.1 requires that delegated duties be congruent with the credentials, qualifications, competencies, and legal scope of practice of the individual receiving them. Standards 7.2 and 7.3 define the respective responsibilities of each party. The PTA must communicate patient status changes that may require plan modification and must work within the established plan of care. The PT bears primary responsibility for supervision of PTAs and support personnel. Standard 7.5 places an affirmative obligation on PTAs to communicate to the supervising PT any area in which they lack the necessary knowledge or skill to practice safely or effectively. These professional standards parallel the statutory framework established by the Practice Act and the Administrative Code. So a PTA who silently continues to perform a treatment technique beyond the scope of established competence may face disciplinary exposure under both the State Practice Act and the APTA Code. Illinois imposes one supervisory provision that departs significantly from the general supervision standard, and it applies in a high-risk procedural context. For a PTA performing dry needling or intramuscular manual therapy, the Administrative Code requires direct line-of-sight supervision by a PT who has satisfied the same prerequisite training requirements applicable to the PTA. This elevated standard means the supervising PT must be physically present in the room and visually monitoring the PTA's technique throughout the procedure. It reflects the invasive nature of needling procedures and the heightened patient safety concerns associated with a PTA performing a skill that carries risks of pneumothorax, vessel injury, and infection if performed incorrectly. Let me be clear about this. A supervising PT who is in an adjacent room, monitoring by camera, or available by telephone is not in compliance with the line-of-sight requirement during a PTA-performed dry needling session, regardless of how well the general supervisory relationship functions in other respects. Telehealth services add another dimension to the supervision framework. Under the 2025 Telehealth Amendments enacted by Public Act 103-849, effective January 1, 2025, a PTA working under the general supervision of a physical therapist and treating a patient located in Illinois through telehealth must be independently licensed or authorized to practice physical therapy in this state. The general supervision obligations of the supervising PT aren't diminished by the telehealth delivery modality. All supervision requirements of the Practice Act and the Administrative Code continue to apply with full force, adapted as necessary to the digital environment. Now let's turn to the supervision requirements for physical therapy aides, PT and PTA students, and license-pending applicants. These requirements reflect the varying levels of training, credentialing, and accountability associated with each personnel category. In each instance, Illinois law places the ultimate supervisory responsibility on the licensed physical therapist, ensuring that all patient care delivered through non-licensed personnel is anchored to professional accountability at the PT level. Physical therapy aides are individuals with on-the-job training specific to the employing facility who aren't graduates of a CAPTA-accredited PTA educational program. Because aides are neither licensed nor formally credentialed by the state, Illinois imposes the most restrictive supervision requirement for this category. Aides may perform patient care activities only under the on-site supervision of a licensed PT or PTA. On-site means physical co-location in the facility at the time the aide is providing patient care activities. Remote, telephonic, or electronic supervision doesn't satisfy this requirement. Like PTAs, aides are prohibited from interpreting referrals, performing evaluation procedures, or planning or making major modifications to patient programs. But because aides lack even the structured educational preparation of PTAs, the practical scope of their permissible patient care activities is necessarily narrow and must be individually defined by the supervising PT or PTA for each facility context. The supervising PT or PTA retains full professional and legal responsibility for all patient care activities in which an aide participates. That accountability can't be delegated through facility policy or employer directive. PT and PTA students engage in supervised clinical practice as a core component of their professional education. Under the Administrative Code, students must practice under the on-site supervision of a licensed physical therapist, who must be readily available for direct supervision and instruction to ensure patient safety and program integrity. Readily available requires more than physical proximity to the building. It requires the ability to observe, intervene, and provide direct guidance promptly whenever the clinical situation demands it. Clinical instructors and site supervisors bear both professional and ethical accountability for patient care provided by students under their direction, consistent with 2026 APTA Code, Standards 7.1 through 7.3, which require that delegated activities be calibrated to the demonstrated competency of the individual performing them. And this point matters. Student errors don't transfer liability away from the supervising PT. The supervising PT's obligation is to ensure that the student is performing within assessed competence and under adequate supervision at all times. License pending applicants are individuals who've completed their professional education and NPTE examination and are awaiting formal licensure following examination results. They occupy a transitional status between student and licensed practitioner. Under the Practice Act and the Administrative Code, a license pending applicant may practice only under the supervision of a licensed PT who is physically present on site. The supervision model for license pending applicants closely tracks the student supervision model, with on-site presence as the core requirement. IDFPR has consistently held that patient care delivered by a license pending applicant in the absence of a qualifying supervising PT on the premises constitutes unauthorized practice of physical therapy, subject to civil penalties of up to $10,000 per instance, regardless of whether the applicant later receives the license. Let's shift now to the documentation requirements and standards that apply to Illinois physical therapy practice. Documentation is both a clinical necessity and a legal obligation for Illinois licensed physical therapists and physical therapist assistants. The Illinois Physical Therapy Act and the Administrative Code require licensees to maintain documentation sufficient to support the care provided and to demonstrate compliance with all applicable provisions of the Act and its administrative rules. Illinois doesn't consolidate all documentation requirements in a single statute, but the combined effect of state law, federal regulatory requirements, payer contracts, and professional standards establishes a thorough and enforceable documentation framework for Illinois PT practice. Record retention obligations arise from multiple overlapping frameworks. General Illinois healthcare facility licensing rules require retention of adult patient records for a minimum of 10 years, with extended periods applicable to records involving minors under juvenile care and other protective statutes. HIPAA's administrative documentation requirements impose a 6-year retention period for policies, procedures, and records of disclosures made in connection with HIPAA-governed activities. Medicare's Program Integrity Guidance recommends a 7-year retention period for records supporting federal health care program claims. Where these frameworks prescribe different minimums, a conservative approach, applying the most protective standard, is appropriate and prudent. That's especially true given the extended statutes of limitations applicable to both civil malpractice actions and Quitam False Claims Act actions under federal law. Licensees should establish written record retention policies. confirm those policies with their facility's legal counsel and professional liability carrier, and audit compliance at regular intervals. Failure to maintain adequate and accurate records relating to the provision of services constitutes unprofessional conduct under Section 17(1)H of the Practice Act. Section 17(1)H broadly targets any departure from the minimal standards of acceptable and prevailing physical therapy practice, and inadequate documentation falls squarely within its reach. This is particularly true of documentation that fails to support billed services, omits required supervisory notations, or misrepresents the nature, extent, or provider of services rendered. A failure by the supervising PT to sign or countersign records in the manner required by the Administrative Code may also be separately cited under Section 17(1)B as a violation of the Act or administrative rules. IDFPR enforcement actions published in the agency's monthly disciplinary reports and publicly accessible on the IDFPR website reflect a consistent pattern of consent orders, fines, and probationary status issued against practitioners who documented treatment time not actually spent with patients, who failed to document PTA or aid supervision, or who couldn't produce records adequate to support billed services. The 2026 APTA Code of Ethics addresses documentation directly and explicitly across multiple standards. Standard 6.2 requires that clinical documentation accurately reflect the provider, nature, and extent of services provided, covering treatment notes, progress reports, flow sheets, discharge summaries, and billing records. Standard 5.1 requires truthful authorship of clinical documentation and patient education materials, prohibiting attribution of record entries to providers who didn't actually render or supervise the documented services. Standard 6.1 requires truthful and accurate representations of services, including billing representations, and is violated by any documentation practice that overstates units of service, treatment time, or clinical complexity to support an inflated reimbursement claim. Taken together, these APTA standards align with and reinforce the Section 17 statutory framework. Documentation integrity isn't merely a billing compliance concern, it's a core professional and ethical obligation that intersects federal fraud and abuse law, state licensure discipline, civil liability, and professional self-regulation. APTA's physical therapy documentation of patient and client management guidance goes further by clarifying the physical therapist's oversight responsibility. The PT retains oversight of all documentation regardless of the practice setting, must ensure that all contributors to the record are appropriately identified, and bears ultimate accountability for the accuracy and completeness of the clinical record. This guidance aligns with the Illinois statutory framework that places final supervisory and documentation accountability at the licensed PT level, even for records that include PTA entries. For PTAs, documentation obligations track their supervisory status. PTAs must document the date and nature of services they provide, and the supervising PT must maintain documentation reflecting the periodic personal supervision and instruction required under the General Supervision Standard. Under the Act and administrative rules, aides may not author independent treatment notes. Aide-performed tasks must be documented within the patient record by the supervising PT or PTA, preserving the legally required chain of professional accountability and preventing the false impression that aide-performed activities were clinician-provided services. Beyond the general documentation obligations that apply across all PT and PTA practice, Illinois law imposes specific documentation requirements in certain high-stakes clinical contexts. Two areas stand out as particularly detailed: direct access practice and dry needling or intramuscular manual therapy. Physical therapists providing services under the direct access provisions of the Practice Act have documentation obligations that extend beyond the standard clinical record. A PT treating a patient without a physician's referral must document the required 5-business-day notification to the patient's treating healthcare professional, including the method of communication used, the date the notification was sent, and the name and contact information of the intended recipient. Where the patient presents with a qualifying chronic disease diagnosis, the PT must document the initiation and maintenance of required monthly communications with the treating provider, including the date and content of each communication. As the 10-visit or 15-business-day re-referral threshold approaches, the patient record must reflect the PT's active tracking of that threshold, and any referral obtained or, if applicable, the basis for any continuation of care under an appropriate exception. Where the PT is providing wound debridement or TMD consultation under direct access, the documentation must reflect the authorization, whether through referral, physician concurrence, or the applicable statutory pathway for those extended services. Failure to document compliance with direct access requirements, particularly when combined with an adverse outcome that prompts a complaint or malpractice action, creates simultaneous exposure under Section 17(1) H for departure from minimal standards of practice, Section 17(1) B for violation of the Act, and common law professional negligence. Dry needling and intramuscular manual therapy documentation requirements reflect the complexity and invasive nature of the procedure and the layered prerequisite obligations imposed by the Administrative Code. A PT or PTA who has completed the 5-element prerequisite sequence should maintain personal documentation of that training. This includes certificates of completion for the required 50 hours of college-level coursework, the 30-hour didactic dry needling program, and the 54-hour supervised practicum. It also includes a log of the required 200 patient sessions of post-training dry needling performed within the 24-month window, and evidence of passage of the required competency examination. These credentials should be retained in the licensee's personal professional file and be available for IDFPR inspection or for use in any disciplinary proceeding alleging unauthorized performance of the technique. For each patient encounter involving dry needling, the clinical record should document the clinical indication for treatment, the informed consent discussion, and the patient's written authorization. A description of the specific technique applied, and the anatomical sites needled, and any adverse events or reactions observed during or after the session. For PTA-performed dry needling sessions, the record must additionally document that the supervising PT was physically present with direct line of sight throughout the procedure, that the supervising PT has independently met the same prerequisite training requirements as the PTA, and the identities of both the performing PTA and the supervising PT. Gaps in this documentation chain create direct disciplinary exposure under Section 17(1) H for inadequate record keeping and Section 17(1) B for violation of the Act and rules, and may serve as evidence of unauthorized practice if the training prerequisites themselves weren't completed. Welcome to Module 4, where we'll turn our attention to continuing education requirements. This module presents the CE requirements that condition every Illinois PT and PTA license renewal, with the precision that compliance demands. We'll cover the total CE hours required per pre-renewal period, the mandatory 3-hour ethics and jurisprudence component that this course fulfills, the self-study cap that changed effective April 5, 2024, the distinction between virtual live CE and self-study, and the 5 co-required topic-specific trainings that operate alongside the general CE structure. Understand from the outset that non-compliance with any of these requirements can escalate beyond a simple administrative deficiency to a formal Section 17 disciplinary proceeding. Let's begin with the general CE requirements and the pre-renewal period. Continuing education is a condition of license renewal for all Illinois licensed physical therapists and physical therapist assistants, reflecting the legislature's recognition that professional competence requires ongoing learning in a field shaped by evolving clinical evidence, advancing technology, and regularly updated legal standards. The governing regulation, 68 Illinois Administrative Code Section 1340.61, establishes the foundational parameters. Every licensed PT must complete 40 hours of continuing education relevant to the practice of physical therapy during each pre-renewal period, while every licensed PTA must complete 20 hours. The pre-renewal period is defined as the 24 months preceding September 30 in the applicable renewal year. For PTs, that means September 30 of even-numbered years, and for PTAs, it's September 30 of odd-numbered years. There's one exemption to be aware of. A renewal applicant is exempt from the CE requirement for the first renewal following original licensure, recognizing that newly licensed practitioners have recently demonstrated current competence through their professional education and NPTE performance, and haven't yet had the full pre-renewal period to accumulate CE. Here's a detail that catches some practitioners off guard. A continuing education hour under Illinois law is defined as 50 minutes of instruction, not a full 60-minute clock hour. This definition applies consistently across all approved CE formats, whether live in-person programs, virtual live programs, or self-study, and it must be applied precisely when calculating compliance with the 40 or 20-hour total, the 3-hour ethics and jurisprudence minimum, and the applicable self-study cap. So what does that mean in practice? A practitioner who completes a 6-hour live continuing education conference is earning 6 CE hours under Illinois rules only if each of those hours corresponds to 50 minutes of instruction. A full-day program with substantial break time built into a stated contact hour count may not actually meet the Illinois definition hour for hour. Section 1340.61b(1) establishes substantive content standards applicable to all CE activities, including those intended to satisfy the ethics and jurisprudence mandate. All CE activities must be relevant to the advancement, extension, and enhancement of providing patient or client management, including physical therapy examination, evaluation, intervention, and prevention, and to fulfilling the professional roles of the PT or PTA. The rule expressly states that CE activities focused on personal estate planning, personal financial planning, personal investments, and personal health are not acceptable. These examples illustrate a broader principle. Any course whose primary focus lies outside the advancement of clinical, scientific, or professional practice skill falls outside the scope of acceptable CE under Illinois law. That includes general workplace management courses, not tailored to healthcare contexts, generic personal development programs, or motivational seminars without substantive professional content, regardless of the sponsor's credentials. Beyond content requirements, all approved CE programs must also meet operational quality standards. Each program must contribute to the enhancement of professional clinical skills and scientific knowledge in physical therapy practice. It must provide experiences with scientific integrity, relevant subject matter, and appropriate course materials. The program must be developed and presented by individuals with relevant education or experience in the subject matter. It must include a mechanism for participant evaluation. It must be open to all licensed PTs and PTAs without restriction to members of a particular organization. And it must specify the number of CE hours applicable to Illinois renewal. These standards apply regardless of whether the program is offered by an automatically approved sponsor or a sponsor approved through the IDFPR application pathway. Now let's look at the 3-hour ethics and jurisprudence mandate and the approved sponsors who deliver that education. Beginning with the September 2016 renewal cycle for physical therapists and the September 2017 renewal cycle for physical therapist assistants, Illinois law requires that at least 3 of the total required CE hours include content related to the ethical practice of physical therapy, including jurisprudence. This mandatory minimum ensures that all Illinois licensees revisit professional ethics and state law at regular renewal intervals. The legislature determined that familiarity with the ethical and legal framework governing practice is a non-discretionary component of professional competence, not an elective enrichment. The administrative rule drafts the ethics and jurisprudence mandate broadly, prescribing that the content must relate to ethical practice and jurisprudence but not dictating specific subtopics or curricular formats within the 3-hour block. In practice, the IPTA Ethics Committee's program content recommendations have become the de facto benchmark shaping what regulators and approved sponsors treat as substantively adequate. The IPTA recommended elements for an approved 3-hour ethics course include the following. First, presentation and discussion of the APTA Code of Ethics for the physical therapy profession, which as of 2026 is the unified code applicable to both PTs and PTAs, replacing the prior separate PT code and PTA standards of ethical conduct. Second, instruction and guided practice in ethical decision-making, with the RIPS model of ethical decision-making strongly recommended as the primary structured framework, ideally paired with group discussion and scenario-based case study application. Third, presentation and discussion of jurisprudence and ethical conduct specific to physical therapy practice in Illinois, including the Illinois Physical Therapy Act, disciplinary grounds, and relevant administrative rules. And fourth, PT-specific substantive content, generic business ethics curricula, general professional development programs, or multi-profession courses without meaningful PT-specific material don't qualify as acceptable substitutes for the Illinois CE ethics and jurisprudence mandate. The categories of automatically accepted CE sponsors under 68 Illinois Administrative Code Section 1340.61c(1) reflect IDFPR's reliance on established professional infrastructure for quality assurance. Automatically accepted sponsors include APTA and its components, including programs, courses, and activities approved by IPTA. They also include FSBPT, as well as CAPTA-accredited colleges, universities, and community colleges offering PT or PTA programs, and any accredited college or university for post-professional academic coursework. Any other person, firm, association, corporation, or group may qualify if approved by IDFPR upon recommendation of the Physical Therapy Licensing and Disciplinary Board under the Section 1340.61c(1)d pathway. The path to becoming a 1340.61c(1)d approved sponsor requires submitting a formal sponsor application to IDFPR with a non-refundable $500 processing fee. Illinois state agencies, state colleges, and state universities are exempt from this fee. The application must include certification of compliance with the substantive and operational CE criteria in Section 1340.61 and a sample 3-hour CE program complete with course materials, presenter qualifications, and a course outline for board review. Once approved, sponsors must renew their status biennially by submitting a renewal application with a $250 fee and a full list of all courses and programs offered within the prior 24-month period. Sponsors must retain attendance records and participant evaluation data for at least 5 years, and every certificate of attendance issued to a participant must include the sponsor's name, the participant's name, a detailed description of the subject matter covered, the number of CE hours actually attended in each topic area, the date of the program, and the sponsor's authorized signature. CE earned from a sponsor in another jurisdiction who isn't among the automatically accepted Illinois categories may still qualify for Illinois renewal through IDFPR's out-of-state approval process. A licensee seeking such approval must submit an out-of-state approval form and a $20 processing fee prior to the program or at least 90 days before license expiration. Late submissions, meaning those arriving after the program has been completed but more than 90 days before expiration, are permitted but carry an additional late fee of $10 per CE hour, capped at $150 total. Licensees planning to rely on out-of-state CE to satisfy their Illinois renewal requirements should confirm eligibility before enrolling. A post hoc denial of sponsor approval can leave an otherwise compliant licensee short of the required hours with limited options for remediation. Let's move on to the self-study cap and virtual live CE. Not all CE delivery formats carry equal weight under Illinois law. Section 1340.61 recognizes 2 primary formats, live attendance and self-study, and caps the proportion of CE hours that may be satisfied through self-study. Understanding this distinction matters a great deal for practitioners who rely heavily on online courses or pre-recorded content to meet their renewal requirements. Self-study CE is defined as CE obtained through correspondence courses or web-based programs, including pre-recorded webinars and asynchronous online courses made available by approved CE sponsors that require the learner to complete the course content and then pass a post-course examination demonstrating comprehension of the material. Prior to 2024, Illinois capped self-study CE at 50% of the total requirement, meaning no more than 20 of 40 PT hours or 10 of 20 PTA hours. Effective April 5, 2024, IDFPR amended Section 1340.61 to raise the self-study cap to 75% of the total CE requirement, as published at 48 Illinois Register, 6034. Under the current rule, a PT may satisfy up to 30 of the required 40 hours through self-study formats, and a PTA may satisfy up to 15 of the required 20 hours through self-study. That's an important change to know about. Practitioners who rely on older CE planning resources, whether printed fact sheets from professional associations, website summaries that haven't been updated since the amendment, or guidance documents predating April 2024, may still show the superseded 50% figure. The current administrative rule controls, and licensees bear personal responsibility for confirming compliance with the in-force standard at the time of renewal. Virtual Live CE is explicitly categorized as live attendance under Illinois CE rules, not as self-study. A virtual live program is one in which the participant attends synchronously, can communicate in real time with the presenter and other participants, ask and receive answers to questions, and engage interactively with the course content as it's delivered. The interactive, real-time nature of virtual live programs distinguishes them from asynchronous, pre-recorded content and ensures that practitioners participating in synchronous online conferences, live webinars, or real-time interactive courses receive full credit as live CE hours. Those hours aren't subject to the self-study cap and don't count toward the 75% maximum. Regardless of format, licensees bear the burden of demonstrating CE compliance. CE completion is self-certified on the renewal application, but IDFPR retains authority to audit CE records at any time following renewal. Licensees must retain documentation of CE completion, including certificates of attendance, course completion notifications, and passing examination scores for self-study courses, for a minimum of 5 years following the close of the pre-renewal period in which the CE was earned. Here's the thing. Absence of supporting documentation in an audit is treated as evidence of non-compliance, not as a technical record-keeping deficiency, and may result in the commencement of formal disciplinary proceedings. Now we turn to the co-required topic-specific trainings. In addition to the 40 or 20-hour general CE requirement and the 3-hour ethics and jurisprudence mandate, Illinois law imposes several co-required topic-specific training obligations on licensed healthcare practitioners, including physical therapists and physical therapist assistants. These requirements are established by separate statutes and administrative rules. They operate independently of and in addition to the general CE structure, and they don't substitute for the 3-hour ethics and jurisprudence requirement. CE hours earned to satisfy these co-required topics may generally be applied toward the 40 or 20-hour total requirement when the training is obtained from an approved sponsor. Let's walk through each of the 5 co-required trainings. First, sexual harassment prevention training is required under 68 Illinois Administrative Code Section 1130.400, which mandates 1 hour of sexual harassment prevention CE every renewal cycle for all IDFPR licensed professionals, including PTs and PTAs. This recurring requirement reflects the statewide policy embedded in the Illinois Human Rights Act and the Illinois Workplace Transparency Act, which together impose affirmative obligations on licensed professionals to maintain current awareness of their legal obligations and professional standards in preventing and responding to sexual harassment in professional settings. Second, implicit bias awareness training was established by 20 ILCS 2105, Section 2105-15.7, effective January 1, 2023, requiring all IDFPR licensed healthcare practitioners to complete 1 hour of implicit bias awareness training every renewal cycle. This requirement reflects the legislature's recognition that documented implicit biases in clinical decision-making contribute to persistent healthcare disparities across racial, ethnic, gender, and socioeconomic lines, and that awareness training constitutes a minimum threshold for professional accountability in addressing those disparities. Third, cultural competency training is required under 68 Illinois Administrative Code Section 1130.5250, which mandates 1 hour of cultural competency CE every 6 years, a longer interval than the annual or biennial requirements for harassment prevention and implicit bias awareness. The 6-year cycle reflects the broader conceptual scope of cultural competency education, which encompasses attitudinal development, knowledge about diverse patient populations, and communication skills that are more appropriately reinforced on a longer horizon than annual regulatory recertification. Fourth, Alzheimer's disease and other dementias training is required under 20 ILCS 2105, Section 2105-365 for any healthcare provider with direct patient interaction with adults age 26 and above. 1 hour of Alzheimer's and dementia awareness training is required every 6 years. This applies broadly to PTs and PTAs in all clinical settings where adult patients are seen, which covers virtually all outpatient, inpatient, home health, and long-term care practice environments. The training is intended to ensure that practitioners recognize the behavioral and functional presentations associated with dementia spectrum conditions, communicate effectively with patients and caregivers, and refer appropriately when cognitive impairment is observed. Fifth, mandated reporter training under the Abused and Neglected Child Reporting Act, known as ANCRA, was standardized and expanded by Senate Bill 3833, effective January 1, 2023. That legislation established a uniform mandated reporter obligation applicable to PTs and PTAs across all practice settings, eliminating prior ambiguity about whether the ANCRA mandate extended to PT practitioners outside traditional healthcare facility contexts. Under the current framework, mandated reporters must complete initial training within 3 months of becoming a licensed mandated reporter. Medical professionals, including PTs and PTAs who work with children, must retake the training every 6 years. Upon each license renewal, reporters must affirm that they understand and acknowledge their obligations as mandated reporters under Illinois law. The Department of Children and Family Services, or DCFS, Mandated Reporter Manual provides updated guidance on recognizing indicators of abuse and neglect and fulfilling reporting obligations through the DCFS hotline. Noncompliance with any co-required training may escalate from an administrative CE deficiency to a formal Section 17 disciplinary proceeding. When IDFPR identifies apparent CE noncompliance during the renewal process, the applicant is notified and given the opportunity to request an interview with the Physical Therapy Licensing and Disciplinary Board. The board may then recommend formal disciplinary proceedings under Section 10-65 of the Illinois Administrative Procedure Act. A finding of noncompliance following formal proceedings may result in fines of up to $5,000 per violation under Section 17 and public reporting of the disciplinary order. Section 17(1)(b), which addresses violation of the Act or administrative rules, and Section 17(1)(g), which addresses failure to respond within 60 days to a written department request, are the grounds most commonly cited when CE noncompliance escalates to formal discipline. A licensee who renews without completing the required CE must file a renewal application, the applicable renewal fee, a written statement of facts describing the noncompliance, and a formal request for waiver. Waiver is available only for good cause as defined by rule, which means either full-time active duty service in the United States Armed Forces during a substantial portion of the pre-renewal period, or extreme hardship established on an individual basis, such as a temporary incapacitating illness documented by a licensed physician, or prolonged hospitalization that prevented CE completion. A hardship waiver may be granted for only one renewal period. No subsequent waiver will be granted to the same licensee for the same basis, and resumption of full CE compliance obligations following a waiver period is mandatory. The bottom line is, practitioners who anticipate difficulty meeting CE requirements due to illness, family crisis, or military deployment should proactively contact IDFPR prior to the renewal deadline, as waiver applications submitted contemporaneously with or before the noncompliance is discovered by the department carry a stronger record of good faith than those submitted only after an audit or complaint. Professional ethics in physical therapy isn't a supplement to clinical competence. It's part of it. The ability to recognize ethically significant situations, to reason through them carefully, and to act in line with professional values even under organizational or financial pressure. That's a dimension of practice quality that the Illinois Physical Therapy Act, the 2026 APTA Code of Ethics for the Physical Therapy Profession, and the Physical Therapy Licensing and Disciplinary Board all take seriously. This module gives you the theoretical and practical foundations for ethical practice in Illinois. We'll cover the conceptual distinctions among ethics, law, morals, and professional standards. We'll examine the bioethical principles and ethical theories that inform the 2026 APTA Code. We'll explore the 5 types of ethical situations encountered in physical therapy practice. And we'll walk through the Realm Individual Process Situation Model, known as the RIPS model, of ethical decision-making, along with its 4-step application framework. Any serious discussion of professional ethics in physical therapy has to start by disentangling 4 related but distinct concepts that clinicians routinely blur in ways that lead to faulty reasoning and inadequate responses when the stakes are high. Those 4 concepts are ethics, law, morals, and professional standards. They overlap in practice, but they operate on different foundations, carry different enforcement mechanisms, and sometimes produce contradictory directives. Recognizing these distinctions isn't just an academic exercise, it's the foundational cognitive skill that separates principled professional reasoning from mere rule-following, or worse, rationalized misconduct. Let's start with ethics itself. Ethics is the systematic study of right action, the philosophical inquiry into what one ought to do and why. It's pursued through theoretical frameworks that provide general principles for evaluating conduct, and through applied domains like bioethics, clinical ethics, and organizational ethics that bring those principles to bear on specific professional contexts. As a discipline, ethics is concerned with justification. It asks not merely what a practitioner decided, but whether that decision can be defended by reference to principles and reasoning that others could share and endorse. The tradition from which contemporary PT ethics draws includes Aristotle's virtue theory, Kant's deontology, Mill's consequentialism, and the 20th century principlism of Beauchamp and Childress, whose four-principle framework of autonomy, beneficence, non-maleficence, and justice became the dominant idiom of U.S. clinical ethics, and is reflected directly in the 2026 APTA Code's 6 foundational principles. Now let's turn to law. Law is the codified body of rules enacted by legislatures, elaborated by administrative agencies, and enforced through civil and criminal mechanisms by the state. In Illinois PT practice, primary law is found at 225 ILCS 90, the Illinois Physical Therapy Act, and 68 Illinois Administrative Code Part 1340, the Implementing Administrative Rules. Law establishes the minimum standards of conduct that IDFPR may enforce through its disciplinary process and that the courts may enforce through civil and criminal proceedings. Here's the critical point. Because law is, by design, a floor rather than a ceiling, compliance with applicable statutes and rules is a necessary but not sufficient condition for ethical practice. A PT who restricts professional conduct to what the law expressly requires has met only a fraction of the obligations imposed by the profession's ethical standards. The third concept is morals. Morals are the personal beliefs, values, and convictions a clinician holds about right and wrong, typically shaped by family background, faith tradition, cultural experience, and lived history. A practitioner's personal morals may align closely with both ethics and law, or they may diverge in ways that create real professional tension, as when a PT's personal convictions conflict with the 2026 Code's Standard 1.1, which prohibits discrimination on the basis of any personal characteristic. Illinois regulatory standards do not permit personal moral convictions to override professional ethical obligations or statutory requirements. The practitioner's controlling obligations are the Code and the Act. And departure from those obligations on the basis of personal moral conviction doesn't constitute a defense to disciplinary action. The fourth concept is professional standards. Professional standards are the norms a profession sets for itself, norms that sometimes reach beyond what law requires and that address domains of conduct law doesn't regulate at all. The 2026 APTA Code is explicit on this point. It states that in some circumstances, APTA may set higher expectations than legal requirements applicable to PT and PTA members that are enforced by state licensing authorities. So a practitioner may satisfy every legal requirement applicable in Illinois and still fall short of the professional standard demanded by the Code. And this isn't a theoretical distinction. Section 17(1)(h) of the Illinois Physical Therapy Act authorizes IDFPR to discipline any PT or PTA for any departure from or failure to conform to the minimal standards of acceptable and prevailing physical therapy practice, and IDFPR regularly cites APTA Code provisions in disciplinary proceedings as evidence of what those minimal standards require. The Code isn't merely a statement of professional aspiration, it's also a legal benchmark. These four domains frequently intersect, but they aren't coextensive. A clinical action can be entirely legal and yet clearly unethical. Consider a productivity quota that complies with every state and federal billing rule but systematically shortens treatment sessions in ways that degrade individualized patient care. Conversely, conduct can be ethical but temporarily illegal, as in the case of a whistleblower whose disclosure of institutional fraud is ethically defensible well before the legal protections of a qui tam proceeding fully attach. Clinicians who grasp these distinctions are far less susceptible to what ethicists call the legality fallacy, the mistaken assumption that because an action is lawful, it must also be ethical. Several other common ethical reasoning errors recur with particular frequency in Illinois PT practice and deserve explicit attention. The first is diffusion of responsibility, the claim that employer directives, payer productivity standards, or institutional policy excuse the practitioner from independent ethical judgment. This is directly and explicitly rejected by 2026 Code Standard 6.7, which prohibits PTs and PTAs from knowingly entering into or continuing any employment or other arrangements that prevent them from fulfilling their professional and ethical obligations to patients and clients, and by Section 17 of the Illinois Act, which holds individual licensees personally accountable for their professional conduct regardless of institutional context. The second is sliding scale rationalization, the incremental acceptance of small ethical compromises that aggregate over time into serious violations. This pattern is documented in the peer-reviewed productivity ethics literature and is among the mechanisms underlying the billing integrity violations captured in Tammany and colleagues' 2019 survey. The third is confidentiality casualness, treating HIPAA as the complete ceiling for information protection. This is particularly dangerous in Illinois because the Mental Health and Developmental Disabilities Confidentiality Act, at 740 ILCS 110, imposes requirements stricter than HIPAA in numerous respects, and where the two laws conflict, MHDDCA controls. Now let's turn to the bioethical principles and ethical theories that underpin contemporary clinical ethics. The bioethical principles that animate clinical ethics in the United States come from a long intellectual lineage. The Hippocratic Oath, originating approximately in the 5th century BCE, articulated the foundational fiduciary duty of the healer and established the principle of primum non nocere, meaning first, do no harm. The Nuremberg Code of 1947 responded to the wartime atrocities of non-consensual human experimentation by articulating informed consent as the first principle of ethical research involving human subjects. The Belmont Report of 1979, produced by the National Commission for the Protection of Human Subjects, identified respect for persons, beneficence, and justice as the three principles governing ethical U.S. research. Beauchamp and Childress's Principles of Biomedical Ethics, first published in 1979 and now in its 8th edition, elaborated these into the four-principle framework of autonomy, beneficence, non-maleficence, and justice that became the dominant idiom of U.S. clinical ethics. The 2026 APTA Code expressly grounds physical therapy ethics in 6 foundational principles, directing PTs and PTAs to carefully consider, balance, and weigh these principles within the context of the situation in making ethical judgments that are in the best interest of the patient or client and society. Let's examine each of these 6 foundational principles. Autonomy is the principle of respecting an individual's right to make informed, self-directed decisions about their own life and body. It grounds the informed consent requirement, the prohibition on coercive care planning, and the patient's right to refuse treatment even when the practitioner believes that refusal is clinically inadvisable. Beneficence is the obligation to take action ensuring the welfare and safety of those entrusted to professional care. It drives the PT's affirmative duties to deliver evidence-based treatment, remain current in clinical knowledge, and refer when another provider is better positioned to meet the patient's needs. Non-maleficence is the principle of preventing or minimizing harm. It operates both as a prohibition against causing injury through clinical action or omission, and as a constraint on beneficence, requiring that the benefits of any intervention be proportionate to its risks. Justice in the 2026 Code's formulation encompasses distributive justice, which is the fair allocation of resources, procedural justice, which is fairness in processes, and recognitional justice, which is the acknowledgement of each person's inherent dignity. Justice requires PTs to provide services without discrimination and to attend to systemic barriers to equitable care. Veracity means honesty and truthfulness in all professional decisions and actions. It grounds the documentation integrity obligations codified in Standards 6.1 and 6.2, and the prohibition on misrepresentation in advertising and credentialing. And finally, fidelity means treating all individuals with respect, fairness, discretion, and integrity. It supports the PT's obligation to maintain therapeutic boundaries, fulfill commitments to patients and referral sources, and uphold the profession's reputation for trustworthiness. These 6 principles don't exist in a vacuum. They're put into action through the theoretical frameworks that clinical ethicists deploy when reasoning through complex situations. Let me walk through the major ones. Deontological or rules-based ethics is associated with Immanuel Kant and grounds moral obligation in duty and principle regardless of consequence. A practitioner reasoning deontologically asks, not, What outcome will this produce? But what rule or duty applies here? This mode predominates when the analysis turns on enumerated Illinois statutory prohibitions, the Code's enforceable standards, and HIPAA's specific disclosure rules. Consequentialist or teleological ethics is associated with John Stuart Mill and Jeremy Bentham, and asks which available action produces the greatest aggregate welfare for those affected. This framework dominates utilitarian arguments about resource allocation, triage decisions, and population-level public health obligations. Virtue ethics, associated with Aristotle and contemporary philosophers, including Alasdair MacIntyre, locates moral authority in character rather than rules or outcomes, asking what a person of excellent professional character would do. This mode is especially congruent with the APTA core values of accountability, integrity, compassion, excellence, and duty. Care ethics, associated with Carol Gilligan and Nell Noddings, foregrounds the relational context of moral decisions, emphasizing that ethical obligations arise within and through relationships of dependency and trust. This framework is particularly apt in physical therapy, where the therapeutic alliance is both clinically significant and ethically constitutive. Finally, principalism, the framework of Beauchamp and Childress, synthesizes these theories by applying autonomy, beneficence, non-maleficence, and justice to specific cases through a process of specification and balancing. This method is well suited to the complex multi-interest situations that arise in clinical practice. Let's shift now to the RIPS model of ethical decision-making. The Realm Individual Process Situation Model, or RIPS for short, was developed by Laura Lee Swisher, sometimes known as Dolly Swisher, along with L.E. Arslanian and C.M. Davis, and was first published in the HPA resource of the section on Health Policy and Administration of the American Physical Therapy Association in 2005 as a thorough ethical decision-making framework designed specifically for physical therapy practice. The IPTA Ethics Committee strongly recommends the RIPS model as the principle-structured framework for Illinois ethics continuing education, and the model has been adopted widely in PT academic programs and by practitioners seeking a systematic approach to ethical reasoning that goes beyond intuition or rule lookup. The RIPS framework draws on the work of Rushworth Kidder's analysis of right versus right ethical dilemmas, Jack Glazer's three-realm model of organizational ethics, James Rest's four-component model of moral behavior, and Ruth Pertillo's classification of ethical situations in healthcare. The first structural component of the RIPS model is the realm, which describes the contextual level at which the ethical decision occurs. There are three realms. The individual realm encompasses ethical issues arising in the direct relationship between the practitioner and the patient or client. This is the traditional domain of biomedical ethics, covering informed consent, confidentiality, and the therapeutic relationship. The organizational or institutional realm encompasses ethical issues that arise from workplace structures, employer policies, productivity demands, institutional resource constraints, and the organizational culture within which care is delivered. This realm is particularly relevant to Illinois practitioners operating in skilled nursing facilities, hospital systems, and privately owned PT practices, where productivity expectations and reimbursement incentives create systemic pressures on clinical decision-making. It's also the realm most directly implicated by Tammany and colleagues' 2019 research finding that organizational culture is the strongest predictor of observed unethical behavior in rehabilitation settings. The societal realm encompasses issues that arise at the level of healthcare policy, resource allocation, public health, and social justice, in which the PT or PTA functions not merely as a clinician responding to an individual patient's needs, but as a participant in a broader social institution with obligations to the public at large. Illinois-relevant societal realm issues include advocacy for equitable access to physical therapy services, participation in public health initiatives, and attention to the systemic drivers of healthcare disparities. The second structural component of the RIPS model is the individual process, which describes the internal moral processing that characterizes ethical decision-making. This component is based on James Rest's four-component model. The first component is moral sensitivity, the capacity to perceive that a situation has ethical dimensions, to recognize that your actions may affect the interests of patients, colleagues, or the public in ways that call for ethical attention rather than purely technical problem-solving. Without moral sensitivity, an ethical issue goes unrecognized, and the practitioner never engages the reasoning process at all. Second is moral judgment, the analytical capacity to determine the ethically appropriate course of action once an issue has been recognized, to weigh applicable principles, apply relevant frameworks, and arrive at a defensible conclusion about what ought to be done. Third is moral motivation, the internal commitment to prioritize ethical values over competing personal, organizational, or financial interests, the disposition that enables the practitioner to choose the right course of action even when doing so is professionally costly or personally inconvenient. And fourth is moral courage, the behavioral component, the willingness to carry out the chosen ethical decision in the face of obstacles, institutional pressure, fear of retaliation, or personal cost. Sound ethical reasoning that generates no real-world action because the practitioner lacks the courage to act on it is, in the RIPS framework, an incomplete ethical response. The third structural component of the RIPS model is the situation, which classifies the nature of the ethical scenario being encountered. There are 5 types of ethical situations. An ethical issue or problem presents genuine uncertainty about the right course of action. An ethical dilemma presents 2 or more mutually exclusive courses of action, each supported by legitimate ethical reasoning. This is the right versus right structure that Kidder's frameworks are designed to analyze, including truth versus loyalty, individual versus community, short-term versus long-term, and justice versus mercy. An ethical distress situation is one in which the practitioner recognizes the right course of action but faces institutional, structural, or relational barriers that impede or prevent carrying it out. This circumstance is documented with particular frequency in productivity-constrained practice environments. An ethical temptation presents a clear right versus wrong choice in which the wrong course offers personal advantage, placing the practitioner's integrity against a self-interested incentive. An ethical silence describes a situation in which professional or ethical values are being violated within an organization or care environment, but no one within that setting is raising, discussing, or addressing the challenge. Getting the classification right at the outset of analysis is critical because different types require different responses. An ethical distress situation calls primarily for strategies to address institutional barriers, while an ethical dilemma calls for strategies to balance competing legitimate claims. Now let's move to how the RIPS model works in practice. Its real value lies in the 4-step application framework, which gives you a structured analytical sequence adaptable to the full range of ethical situations encountered in Illinois PT practice and across all patient populations. Step 1 is to recognize and define the ethical issues. This step requires the practitioner to exercise moral sensitivity, to perceive that the situation involves genuine ethical stakes, calling for structured ethical reasoning rather than purely clinical or administrative problem solving. Applying the RIPS framework here means identifying which of the 3 realms, individual, organizational, or societal, the situation primarily engages. It means determining which components of the individual process, whether moral sensitivity, judgment, motivation, or courage, are most centrally implicated. And it means classifying which type of ethical situation, whether issue, dilemma, distress, temptation, or silence, most accurately describes what's occurring. Precision in Step 1 matters a great deal because the diagnostic classification of the situation type shapes the entire reasoning strategy that follows. Step 2 is to reflect. This step requires a systematic gathering and assessment of the information relevant to the ethical decision. Reflection at this stage involves identifying all stakeholders whose interests are affected, including the patient and family members, the payer, the employer and institutional hierarchy, colleagues, other patients competing for limited resources, and the public. It requires identification of all applicable legal obligations, including relevant provisions of 225 ILCS 90, the administrative rules in 68 Illinois Administrative Code, Part 1340, HIPAA, MHDDCA at 740 ILCS 110, the Abused and Neglected Child Reporting Act, the Adult Protective Services Act, and Federal Fraud and Abuse Law, as well as the applicable standards and aspirational provisions of the 2026 APTA Code. It also requires identification of relevant organizational policies, employment contracts, and professional relationships. The purpose of this thorough information gathering isn't to produce a predetermined conclusion, but to ensure that the decision reached in the next step rests on a full and accurate understanding of the ethical situation, rather than a partial or distorted one. Step 3 is to decide on a course of action. This step involves selecting a reasoning approach or a combination of approaches suited to the situation type and stakeholder structure. Rules-based reasoning follows applicable rules, regulations, standards, and codes and is most powerful when codified obligations clearly resolve the ethical question, as when a mandatory reporting obligation under Section 1710 unambiguously applies to a specific factual situation. Ends-based reasoning aims at the best aggregate outcome for all affected parties and is most useful when consequences are measurable and widely distributed, as in resource allocation decisions affecting access to care. Care-based reasoning chooses the course of action that preserves relational trust and human dignity, asking what the practitioner would want done if the roles were reversed. This mode is most congruent with the fidelity and compassion principles at the heart of the therapeutic relationship. The RIPS model also encourages moral imagination at this stage, the deliberate effort to consider whether there's a course of action beyond the obvious alternatives, one that may better serve all competing interests without requiring a stark trade-off. Step 4 is to implement, evaluate, and reassess. This final step requires moral courage, taking the action that ethical reasoning has identified as appropriate, even in the face of resistance, inconvenience, or personal risk. Evaluation follows implementation. Did the action produce the anticipated outcome? Were there unexpected or collateral consequences? Did the action generate new ethical questions? Reassessment feeds back into Step 1, where additional ethical issues have emerged, creating a recursive rather than simply linear decision-making process that mirrors the iterative nature of clinical care itself. The 2026 APTA Code reinforces this reflective loop in its aspirational provisions, calling for professional development grounded in critical self-assessment and the ongoing maintenance of professional competence over the career. Here's where the model's significance for Illinois PT practice really comes through. The RIPS model's explicit recognition of the organizational and societal realms makes it particularly suited to analyzing the productivity pressure and billing integrity scenarios that IDFPR enforcement patterns and peer-reviewed research have identified as among the most frequent sources of ethical violations in physical therapy settings. Tammany, O'Connell, Allen, and Brisme's 2019 cross-sectional survey of 3,446 licensed PT clinicians found that productivity goals in rehabilitation practice were associated with the rate of observed unethical behavior, that skilled nursing facility settings reported approximately 4 times the frequency of high-frequency unethical behavior compared with all other settings, and that organizational culture, not individual moral character, was the strongest predictor of observed unethical organizational behavior. Those findings confirm that ethical failures in physical therapy are predominantly organizational realm phenomena, precisely the domain that the RIPS model and 2026 Code Standard 6.7 are designed to address. Sousa, Goncalves Lopez, and Abreu also demonstrated in 2021 that RIPS-based ethical analysis remains applicable and instructive across varied clinical populations, including older adults with complex comorbid conditions, supporting the model's value throughout the full spectrum of Illinois PT practice settings. Now that we've built the ethical reasoning framework through the RIPS model, this module examines the professional standards within which that reasoning operates. The 2026 APTA Code of Ethics for the Physical Therapy Profession represents the most significant revision of professional ethical standards in the history of American physical therapy, and its effective date of January 1, 2026, means that every Illinois PT and PTA practicing today operates under its requirements. In this module, we'll examine the code's architecture, its transition rules for pre-2026 conduct, and its landmark provisions addressing artificial intelligence and emerging technologies. We'll survey all 9 ethical commitments with attention to the standards most frequently implicated in Illinois disciplinary proceedings. And we'll address in depth the 2 patient rights topics that Section 17 of the Illinois Physical Therapy Act and the FSBPT and IDFPR disciplinary frameworks treat as among the most significant sources of licensee exposure, informed consent, and confidentiality. On July 14, 2025, the APTA House of Delegates adopted the Code of Ethics for the Physical Therapy Profession, which became effective January 1, 2026. This landmark document replaced 2 previously separate instruments: the Code of Ethics for the Physical Therapist and the standards of ethical conduct for the physical therapist assistant. In their place, it established a single, unified code applicable to both physical therapists and physical therapist assistants. That consolidation reflects the profession's recognition that PTs and PTAs share a common ethical foundation, and that a unified code better serves the public's interest in clear, consistent professional standards than two parallel instruments that could be read to impose different ethical obligations on different members of the PT team. Two transition rules are essential for any practice decision or complaint proceeding in 2026 or 2027. First, conduct occurring on or after January 1, 2026, is assessed under the 2026 Code. Second, conduct occurring before January 1, 2026, continues to be evaluated under the prior PT Code of Ethics and PTA Standards of Ethical Conduct, with a transition window extending through December 31, 2027, to permit complaints involving pre-2026 conduct to be processed under the rules in effect at the time of the conduct. If you're an Illinois practitioner or employer involved in any APTA EJC proceedings during this transition window, make sure that the code version applied corresponds to the date of the conduct at issue, not the date the complaint was filed or the proceeding commenced. The architecture of the 2026 Code is organized around two structurally distinct categories of provision within each of its 9 ethical commitments. Standards of conduct, numbered in the format 1.1, 1.2, 2.1, 2.2, and so forth, are enforceable by the APTA EJC against APTA members and constitute the binding professional rules to which APTA membership commits practitioners. Aspirational illustrative examples, lettered in the format 1.A, 1.B, 2.A, 2.B, and introduced with the phrase shall strive, describe ideal professional conduct without being independently enforceable as binding standards. They communicate expectations and illuminate the aspirational targets toward which members are directed. The distinction matters in enforcement. A member may face an EJC proceeding for violating an enforceable standard. That same member wouldn't face a direct EJC sanction solely for failing to achieve an aspirational example, though the overall pattern of professional conduct, including the degree of effort directed toward aspirational ideals, may be considered in broader conduct assessments. Although the APTA Code is enforceable only through the EJC against APTA members, its professional standards reach further into Illinois regulatory enforcement through Section 17(1)H of the Illinois Physical Therapy Act, which authorizes IDFPR to discipline any PT or PTA for any departure from the minimal standards of acceptable and prevailing physical therapy practice. IDFPR regularly cites APTA Code provisions in disciplinary proceedings as evidence of what those minimal standards require, a practice that extends the Code's operative reach to all Illinois PT and PTA licensees, regardless of APTA membership status. So even if you aren't an APTA member, these standards carry real regulatory weight in Illinois. The 2026 Code was deliberately modernized to address the ethical dimensions of artificial intelligence and other emerging technologies, a development that members of the APTA EJC have described as central to the revision's purpose. 3 aspirational provisions have particular practical significance for contemporary Illinois PT practice. Aspirational 3.D, under accountability, calls on practitioners to strive to be accountable for the accuracy and truthfulness of information they disseminate, including information generated or distributed through emerging technologies such as social media and artificial intelligence. Aspirational 5.C, under compassion and trust, asks practitioners to recognize the public trust placed in healthcare professionals and to maintain professional responsibility when information is disseminated through current and emerging technologies. And Aspirational 8.A, under professional expertise, addresses the competency obligation most directly. Practitioners shall strive to develop and maintain competence and exercise appropriate care in using current and emerging technologies, including but not limited to social media and artificial intelligence. So what does that mean in practice for Illinois clinicians? AI documentation tools that generate inaccurate or hallucinated clinical content can't insulate a PT from responsibility under Standard 6.2 for inaccurate documentation. Clinical decisions made with AI-assisted decision support must reflect the PT's independent professional judgment rather than uncritical deference to algorithmic output. and patient data processed through AI platforms must be handled in compliance with HIPAA and, where applicable, the MHD-DCA. Let's turn now to the 9 ethical commitments that form the backbone of the 2026 Code. Each commitment addresses a distinct dimension of physical therapy professional life, from the individual clinical encounter to organizational accountability to societal responsibility. Illinois practitioners should be familiar with each commitment structure and, in particular, with the standards most directly implicated in state regulatory and disciplinary proceedings. Commitment 1, which addresses respect, grounds the Code's most fundamental patient protection obligations. Standard 1.1 prohibits discrimination on the basis of any personal characteristic, establishing a non-negotiable baseline for patient access and dignity that intersects with the Illinois Human Rights Act and the anti-discrimination provisions embedded in Illinois healthcare facility licensing requirements. Standard 1.2 requires practitioners to protect confidential patient information from unauthorized disclosure, consistent with applicable law. This is a standard that must be read in Illinois alongside the strict requirements of the MHD-DCA and HIPAA, which we'll address in detail later in this module. Commitment 2, which addresses integrity, contains several standards with direct implications for Illinois practice. Standard 2.1 confirms that the physical therapist retains full professional responsibility for all physical therapy services provided under the PT's license, regardless of the supervisory or delegation arrangements in place, a principle that reinforces the supervisory accountability framework we examined in Module 3. Standard 2.2 establishes the ongoing informed consent obligation we'll address shortly. Standard 2.3 requires PTs and PTAs, who, in their reasonable judgment, have knowledge that raises a substantial question as to whether a colleague is unfit to perform their professional responsibilities with competence and safety, to report this information to the appropriate authorities. That's a professional obligation paralleling Section 17(1)(f) of the Illinois Act, which authorizes discipline for any licensee who aids or assists another in violating the Practice Act. Standard 2.4 requires addressing known illegal or unethical acts by PT personnel. And Standard 2.5 mandates compliance with mandatory reporting laws, requirements that directly engage the ANCRA and Adult Protective Services Act obligations we addressed in Module 4. Commitment 3, which addresses accountability, includes standards limiting practice to established professional, jurisdictional, and personal scopes under Standard 3.1, requiring practice free from the impairing effects of substance misuse, cognitive deficiency, or mental illness under Standard 3.2, and mandating compliance with all applicable laws under Standard 3.3. Together, these standards reinforce the Section 17 grounds for discipline related to practice beyond scope under Ground V, impairment under Grounds I, J, and Q, and legal noncompliance under Ground B. Commitment 4, maintaining professional relationships, addresses the boundaries of professional relationships. Standard 4.1 prohibits abusive exploitation of those over whom the PT or PTA has supervisory, evaluative, or other authority. Standard 4.2 prohibits sexual relationships with patients, supervisees, or students. Standard 4.3 prohibits verbal, physical, emotional, or sexual harassment of any kind. And Standard 4.4 requires that a PT who terminates the provider relationship while the patient continues to need care must provide reasonable notice and information about alternative sources of care, an obligation that intersects with the prohibition on patient abandonment in Section 17(1)(n). Commitment 5, Compassion and Trust, addresses the communication obligations central to the therapeutic relationship, requiring provision of information necessary for informed decisions under Standard 5.1 and efforts to address barriers to communication and comprehension under Standard 5.2. Commitment 6, Responsible Business and Organizational Practices, is among the most practically significant for Illinois practitioners. It contains standards requiring truthful representation in billing under Standard 6.1, accurate documentation reflecting the provider, nature, and extent of services under Standard 6.2, disclosure of and freedom from conflicts of interest under Standard 6.3, avoidance of gifts or considerations that influence clinical judgment under Standard 6.4, disclosure of financial interests in recommended products or services under Standard 6.5, advanced disclosure of financial obligations to patients before charges are incurred under Standard 6.6, and the prohibition on knowingly entering into or continuing any employment or other arrangements that prevent fulfillment of professional and ethical obligations to patients and clients under Standard 6.7. Commitment 7, Direction and Supervision, tracks the Illinois Practice Act's PTA supervision framework. Standard 7.1 requires calibration of delegated duties to the credentials, qualifications, competencies, and legal scope of practice of the delegated individual. Standard 7.2 requires PTA communication of patient status changes that may require plan modification. Standard 7.3 requires PT assumption of primary responsibility for supervision of PTAs and support personnel. Standard 7.4 requires PTA support of the PT supervisory role. And Standard 7.5 requires PTA communication to the supervising PT of any area in which the PTA lacks the knowledge or skill to practice safely. Standards 7.1 through 7.5 mirror the Illinois statutory supervision framework and are directly implicated by Section 17.1 X and Section 17.1 Y disciplinary grounds. Commitment 8. Professional expertise requires that practitioners maintain competence within their scope and practice consistent with accepted current standards of care under Standards 8.1 and 8.2. Commitment 9. Societal responsibility is unique in the Code in being entirely aspirational. Its provisions, 9.A through 9.H, call on practitioners to engage with social determinants of health, provide pro bono services, engage in interprofessional collaboration, advocate to reduce health disparities, and steward limited healthcare resources, but they don't generate directly enforceable EJC obligations. Underlying the entire Code are the APTA core values: accountability, altruism, collaboration, compassion and caring, duty, excellence, integrity, and social responsibility. These values inform interpretive assessment of standards in cases where their application to specific conduct is contested. Informed consent is simultaneously a legal requirement and an ethical foundation of physical therapy practice in Illinois, grounded in the patient's fundamental right to make autonomous, knowing decisions about the interventions applied to their body. Illinois informed consent doctrine reflects the state's recognition, codified in the Medical Patient Rights Act, that patients possess enforceable rights regarding the information disclosed to them before medical intervention. These include the right to receive truthful and complete information about proposed treatments, available alternatives, and the risks of refusing recommended care. Failure to obtain adequate informed consent before a PT intervention may constitute a departure from the minimal standards of acceptable and prevailing PT practice under Section 17.1 H, generating independent disciplinary exposure. The FSBPT Informed Consent Guide for Physical Therapy, published in May 2025, defines informed consent as the right of the patient or the patient's authorized representative to either pursue or refuse physical therapy services, in whole or in part, following reasonable disclosure of relevant information. The guide identifies 4 categories of information that must be disclosed before physical therapy intervention: the nature, benefits, and risks of the proposed treatment, the alternatives to proposed care, the risks of refusing the recommended treatment, and the identity and qualifications of the providers who will deliver services. This 4-element framework applies across the full spectrum of PT interventions, from routine therapeutic exercise and manual therapy to advanced procedural skills, including dry needling, with the depth and specificity of disclosure calibrated to the complexity and invasiveness of the proposed intervention. A fundamental principle emphasized in both the FSBPT Guide and the 2026 APTA Code is that informed consent isn't a single event at the initiation of care, but an ongoing process throughout the episode of treatment. Standard 2.2 codifies this requirement, obligating PTs and PTAs to obtain ongoing informed consent after providing information that is understandable, honest, and necessary to allow the patient or their surrogate to make informed decisions about participation in physical therapy services or research. The ongoing consent requirement means that a patient who initially consents to a particular treatment approach retains the right to reassess, modify, or withdraw consent as treatment progresses, as clinical circumstances change, or as new information emerges. And the practitioner bears the continuing obligation to ensure that the patient's understanding and agreement remain current. Several clinical contexts in Illinois PT practice require heightened attention to the content and documentation of informed consent. For pelvic health and intimate area treatments, the standard of practice calls for explicit written consent before initiating intimate area interventions, documented reconsent at each visit, addressing the specific treatment components to be provided, availability of chaperones where clinically appropriate, and explicit reiteration at each encounter of the patient's right to discontinue treatment at any time. For dry needling and intramuscular manual therapy, the treating PT must ensure informed consent specifically addresses the nature and purpose of the technique, its material risks, including bruising, soreness, vasovagal response, and the rare risk of pneumothorax when needling cervical or thoracic musculature, as well as the distinction between dry needling as authorized under Illinois law and acupuncture, which requires separate licensure. For telehealth-delivered PT services, verbal or written consent should be obtained and documented prior to the initiation of remote services, consistent with the patient rights provisions enacted by Public Act 103-849. Capacity to consent, meaning the patient's actual cognitive and decisional ability to understand, appreciate, reason through, and communicate a decision, is distinct from legal competence, which is a court-determined status that physical therapists don't assess or declare. When a patient appears to lack capacity, the PT must proceed through the applicable surrogate consent framework under Illinois law. The Healthcare Surrogate Act establishes the hierarchy of persons authorized to make healthcare decisions for adults lacking decisional capacity, beginning with an agent under a durable power of attorney for healthcare and descending through a specified priority order of family members. For minor patients, consent must be obtained from a parent or legal guardian. The Consent by Minors to Healthcare Services Act recognizes limited categories of minor self-consent that PT practitioners working with adolescent populations in sports medicine, pelvic health, or school-based settings must understand and apply correctly. Standard 2.2's requirement that consent information be understandable to the patient or surrogate imposes an obligation to assess comprehension and address communication barriers, including language barriers, low health literacy, and cognitive or sensory impairments before proceeding. Confidentiality of patient health information is simultaneously a legal mandate and an ethical imperative in Illinois physical therapy practice, grounded in the principle of respect for patient autonomy and operationalized through an overlapping framework of federal and state law. Physical therapists who transmit health information electronically in connection with covered transactions are covered entities under HIPAA and must comply with the HIPAA privacy rule governing the use and disclosure of protected health information, or PHI. The security rule establishing administrative, physical, and technical safeguards for electronic PHI, and the breach notification rule requiring timely notification of affected individuals, the Department of Health and Human Services, and in some cases the media following a breach. The HIPAA minimum necessary standard limits the use and disclosure of PHI to the minimum amount reasonably necessary to accomplish the stated purpose, a standard applicable to clinical documentation, referral communications, and any disclosure in connection with treatment, payment, or healthcare operations. Common HIPAA compliance challenges in Illinois PT practice include social media content. No PHI may be included in publicly accessible social media posts without specific written authorization from the patient, and this prohibition applies to before and after treatment photographs and to any post that could identify a patient by implication, even without naming them. The 2026 Code's aspirational provisions on social media in Standards 3.D, 5.B, and 5.C reinforce this requirement. Secure messaging standards require that text messages and emails containing PHI be encrypted or otherwise protected consistent with the security rule's technical safeguard requirements. And waiting room privacy practices, ensuring that patient-provider conversations can't be overheard by other patients, implicate both the minimum necessary standard and the dignity obligations of Standard 1.1. The MHD-DCA is among the most stringent mental health confidentiality statutes in the United States, and is frequently misunderstood or overlooked by physical therapists who assume that HIPAA represents the complete confidentiality framework applicable to their practice. Here's something many PTs don't realize. The MHD-DCA defines therapist far more broadly than its clinical treatment connotation suggests, encompassing psychiatrists, physicians, psychologists, social workers, nurses, or any other person not prohibited by law from providing such services or from holding himself out as a therapist if the recipient reasonably believes such person is permitted to do so. Physical therapists who provide rehabilitative services to recipients of mental health or developmental disabilities services in integrated care settings, including hospital-based outpatient clinics, behavioral health organizations, and transitional living programs, may fall within the MHD-DCA's definition of therapist for those interactions triggering the Act's strict confidentiality requirements. The MHD-DCA's definition of confidential communication encompasses not only the substantive content of mental health treatment communications, but information indicating that a person is a recipient of mental health services. That means even confirming that a specific individual has received or is currently receiving mental health or developmental disabilities services may constitute a protected disclosure under the Act. Authorization for disclosure under the MHD-DCA must satisfy state-specific consent elements that frequently exceed what HIPAA requires, including a calendar expiration date for the authorization's validity and specificity regarding the scope of information to be disclosed and the purpose of the disclosure. House Bill 3078, signed into law August 15, 2025, amended Section 5 to remove the prior witness signature requirement, so consent and revocation under the MHD-DCA no longer require a witness. A subpoena for mental health records or communications subject to the MHD-DCA is not by itself sufficient to compel disclosure. A written court order expressly authorizing the issuance and disclosure of the subpoenaed records or written patient consent satisfying the requirements of Section 5 of the Act must accompany the subpoena before the practitioner may release the records. Where the MHD-DCA's requirements conflict with or exceed those of HIPAA, the stricter MHD-DCA provisions control. Violations of the MHD-DCA expose practitioners to civil liability, including compensatory damages and attorney's fees, and may constitute a criminal misdemeanor, consequences that apply independently of any IDFPR disciplinary proceeding. The practical implications for Illinois PT practitioners are concrete. When treating patients with documented or suspected comorbid mental health conditions in any care setting, apply the MHD-DCA's stricter standards to any information constituting a confidential communication and use authorization forms specifically tailored to the Act's consent element requirements rather than standard HIPAA authorization forms. When you receive a subpoena for any records that may include mental health information, immediately verify whether a court order is attached and consult legal counsel before releasing any materials if the applicability of the MHD-DCA to the specific records is uncertain. In integrated practice settings where physical therapy and mental health services are co-delivered, record systems should be designed to segregate MHD-DCA protected information from the broader medical record in a manner that permits disclosure of non-MHD-DCA information without inadvertently exposing protected mental health communications. Standard 1.2 of the 2026 APTA Code reinforces all of these obligations by requiring practitioners to protect the confidential nature of patient information in accordance with applicable laws and regulations, a standard whose content in Illinois is shaped by both HIPAA and the MHD-DCA. Welcome to Module 7, Enforcement, Discipline, Fraud, and Emerging Issues. Now that we've examined the professional standards that define ethical practice, this module turns to what happens when those standards are violated. The regulatory system governing Illinois physical therapy practice gets its real force through enforcement. Without credible accountability mechanisms, everything we've covered in this course would function as aspirational guidelines rather than legally binding obligations. This module examines the enforcement architecture of the Illinois Physical Therapy Act from the perspective of consequence and liability. We'll cover the disciplinary grounds most critical to fraud, billing integrity, and impairment. We'll walk through the IDFPR disciplinary process and its civil malpractice counterpart. We'll examine the federal and state statutes that criminalize and penalize billing fraud and referral relationship violations. And we'll explore emerging ethical challenges, including artificial intelligence, social media, practitioner well-being, and mandatory reporting that extend professional accountability into domains earlier generations of practitioners simply didn't encounter. Together, these topics fulfill Learning Objective 7, which asks you to state the key elements of federal and Illinois fraud and abuse laws applicable to physical therapy billing and referral relationships, including the False Claims Act, Anti-Kickback Statute, and Illinois Healthcare Worker Self-Referral Act. Let's begin with Section 1, covering the Section 17 grounds for discipline and the IDFPR disciplinary process. The 26 enumerated grounds for discipline under the Illinois Physical Therapy Act, introduced in Module 1 as the regulatory foundation of IDFPR's enforcement authority, take on their full enforcement significance when you examine them alongside the IDFPR disciplinary process and the civil malpractice framework that runs concurrently with regulatory proceedings. This section focuses on the grounds most consequential to fraud, billing integrity, impairment, and mandatory reporting, the enforcement domains that generate the greatest volume of PT and PTA disciplinary action in Illinois. We'll also provide the civil liability context in which professional accountability extends beyond licensure to financial exposure. Ground H is the central enforcement provision for quality of care and billing integrity violations. It addresses dishonorable, unethical, or unprofessional conduct of a character likely to deceive, defraud, or harm the public, including any departure from or failure to conform to the minimal standards of acceptable and prevailing physical therapy practice. Here's the key point. Under Ground H, no actual patient injury needs to be established. The potential for harm to the public is sufficient to support disciplinary action. This no-injury standard gives IDFPR the authority to discipline practitioners for systemic billing and documentation practices that haven't yet caused a measurable adverse patient outcome. A pattern of billing for services not rendered that generates reimbursement without triggering any identifiable patient complaint can still result in discipline. The pairing of Ground H with Ground B, which covers violations of the Act or administrative rules, ensures that virtually every specific regulatory violation generates at least 2 concurrent disciplinary grounds, and penalties attributable to each violation accumulate independently, up to the $5,000 fine per violation authorized by Section 17. The civil penalty for unlicensed practice of physical therapy rises to $10,000 per offense, and unauthorized use of protected PT or PTA titles is a Class A misdemeanor for a first offense and a Class 4 felony for any subsequent offense. Grounds O and P create direct disciplinary consequences for any PT or PTA who knowingly observes indicators of abuse and fails to report. Ground O reaches willful failure to report suspected child abuse or neglect under the Abused and Neglected Child Reporting Act. Ground P reaches willful failure to report suspected elder abuse or neglect. One thing to be aware of: the statutory cross-reference in the Practice Act still names the Elder Abuse Reporting Act, which has since been renamed and is now codified as the Adult Protective Services Act. Courts and regulatory bodies have interpreted willful failure to report to encompass knowing disregard of a recognized reporting obligation in the face of facts that would cause a reasonable practitioner in the same position to report. The consequence of Grounds O and P in licensure discipline is concurrent with the criminal misdemeanor penalty available under the reporting statutes themselves, and either or both consequences may be imposed independently. The legislature has simultaneously provided a clear path to immunity. Good faith reporters acting on reasonable professional suspicion are immunized from civil, criminal, and professional discipline consequences for the making of a report, even if the subsequent investigation doesn't substantiate the abuse. Grounds I, J, and Q address impairment-related conduct. Ground I covers unlawful distribution or conversion of drugs or narcotics. Ground J addresses habitual or excessive use of, or addiction to alcohol, narcotics, stimulants, or other chemical agents resulting in inability to practice with reasonable judgment, skill, or safety. Ground Q covers physical illness, including deterioration through aging or loss of motor skill, that similarly impairs the ability to practice safely. Each is an independent basis for refusal to renew, revocation, suspension, probation, reprimand, or fine up to $5,000 per violation. Unlike some states that maintain dedicated substance abuse rehabilitation programs within their PT practice acts, Illinois addresses practitioner impairment primarily through Section 17's disciplinary grounds and through voluntary professional health resources, including APTA member assistance programs. When a practitioner voluntarily self-refers to a recognized treatment program before a formal IDFPR complaint or department action is initiated, that proactive step may, depending on the specific facts and IDFPR's assessment, mitigate the resulting licensure consequences. Licensees contemplating voluntary disclosure to IDFPR should obtain independent legal counsel before any such disclosure, because the interaction between voluntary treatment and the impairment grounds under Section 17 is highly fact-specific. Illinois civil malpractice law provides a complementary accountability framework that operates entirely independently of IDFPR disciplinary proceedings. To prevail in a civil malpractice action against a PT or PTA, a plaintiff must establish 4 elements. First, a duty of care arising from the professional relationship defined by the applicable standard of care. Second, a breach of that duty through action or omission. Third, direct causation of the plaintiff's injury by that breach. And fourth, actual harm, whether physical, emotional, or financial, suffered as a result. Illinois doesn't impose a statutory cap on non-economic damages in medical malpractice actions. The Illinois Supreme Court's 2010 decision in LeBron v. Gottlieb Memorial Hospital struck down an earlier statutory cap as unconstitutional, and no legislative replacement is currently in force. The applicable statute of limitations generally requires that a malpractice action be commenced within 2 years of the date the plaintiff knew or reasonably should have known of the injury, with an absolute repose period of 4 years from the date of the alleged act or omission, subject to extensions for minors and persons under legal disability. Illinois plaintiffs must additionally file an attorney affidavit and a written report by a qualified health professional supporting the claim's merit. HPSO-CNA, which stands for Healthcare Provider Service Organization, and CNA Insurance, provides professional liability data that identify the most frequent malpractice allegations against PTs. These include improper management over the course of treatment, inappropriate behavior, and fraudulent billing. The average paid indemnity is approximately $95,000 per claim, and average total claim costs are approximately $119,000, including defense expenses. So what does that mean in practice? A PT may be legally authorized under the Practice Act to perform a clinical technique, yet still face malpractice liability if the practitioner lacks the clinical competence, meaning the knowledge, skill, and judgment, to perform it safely in the specific patient's circumstances. Standard 8.1 of the 2026 APTA Code codifies this principle, obligating physical therapists to recognize and practice within the limits of their skills and competence, and to refer a patient or client to another healthcare professional when it's in the best interests of the patient or client. This standard and Section 17's Ground H operate in concert, establishing the same conduct standard from 2 independent directions, one professional and one regulatory. The IDFPR disciplinary process, introduced in Module 1, resolves the vast majority of matters at the informal disciplinary conference stage. More than 90% of all IDFPR disciplines across regulated professions result from negotiated consent orders or stipulations of facts and recommendations for settlement, rather than formal evidentiary hearings. A consent order may impose conditions ranging from a formal reprimand without suspension to probationary periods requiring mandatory supervision, continuing education, psychological evaluation, or monetary fine. IDFPR's monthly disciplinary reports are publicly accessible and constitute a permanent, searchable record of disciplinary action, discoverable by employers, credentialing bodies, malpractice insurers, and individual patients. That transparency consequence is something every practitioner must weigh when assessing the full implications of any disciplinary resolution. Let's shift to Section 2, Federal Fraud and Abuse Laws. Every licensed healthcare professional providing services to patients covered by Medicare, Medicaid, or other federal healthcare programs, including Illinois PTs and PTAs, operates within the concurrent jurisdiction of federal fraud and abuse authorities. Any one of these authorities can independently generate civil or criminal liability without reference to state disciplinary proceedings. The 5 authorities most directly applicable to physical therapy billing and referral relationships are covered in this section. The False Claims Act, or FCA, is the primary federal civil statute governing billing fraud against federal healthcare programs. The FCA imposes liability on any person who knowingly presents or causes to be presented a false or fraudulent claim for payment to the United States government. Knowing is defined by statute to encompass actual knowledge, deliberate ignorance of the truth or falsity of information, and reckless disregard of the truth or falsity. No specific intent to defraud is required. Violations carry treble damages, meaning 3 times the amount falsely claimed, so even modest billing fraud generates liability far exceeding the original amount. Per-claim civil penalties are also imposed and adjusted annually. The FCA's quitam provision allows private individuals, known as relators, to file suit on the government's behalf and share in any financial recovery. These relators can include PT employees, co-workers, and billing staff who possess inside knowledge of fraudulent practices. They file sealed complaints on the government's behalf and share in any resulting recovery. This whistleblower mechanism has driven a large proportion of FCA settlements involving physical therapy, and the relator plaintiff in many significant PT sector cases is a former employee who personally participated in or was pressured to participate in the fraudulent billing scheme. Physical therapy-specific FCA exposure patterns include billing for services not rendered, billing for one-on-one treatment when group therapy was actually provided, upcoding current procedural terminology codes, commonly known as CPT codes, to reflect more complex services than those delivered, failing to satisfy Medicare's 8-minute rule for time-based CPT codes, and submitting documentation that overstates treatment duration or misidentifies the treating provider. The Medicare 8-minute rule determines billable units for time-based CPT codes under Medicare Part B. A single-timed service of at least 8 minutes earns 1 billable unit. 23 minutes earns 2 units. 38 minutes earns 3 units, with subsequent units accumulating at 15-minute intervals thereafter. Because the 8-minute rule is enforced through documentation review, any discrepancy between documented treatment time and billed units creates immediate FCA exposure. A pattern of such discrepancies can be sufficient to trigger both FCA civil liability and disciplinary proceedings under Section 17's Ground H. The Anti-Kickback Statute, or AKS, criminalizes the knowing and willful offer, payment, solicitation, or receipt of remuneration to induce or reward the referral of federal healthcare program patients. Remuneration includes money, services, equipment, free rent, or any other item of value. Penalties include criminal fines up to $100,000 per violation, imprisonment up to 10 years, and mandatory or permissive exclusion from federal program participation. Remuneration is defined broadly and encompasses any item with value exchanged in connection with a referral relationship, regardless of the form it takes. Statutory and regulatory safe harbors define categories of transactions that don't violate the AKS. These include bona fide employment relationships, personal services and management contracts meeting specified criteria, and space and equipment rental arrangements at fair market value. However, arrangements that don't satisfy the technical requirements of a safe harbor are evaluated under the totality of the circumstances standard applied by the Office of Inspector General, or OIG, and the Department of Justice. PT-relevant kickback patterns include below-market rent from a referring physician in exchange for preferential referral, bonuses explicitly linked to referral volume from a specific source, and gifts, meals, or cash provided to referral source staff for access to referral lists. The Physician Self-Referral Law, commonly known as the Stark Law, prohibits physicians from referring Medicare and Medicaid patients for designated health services to any entity in which the physician or an immediate family member has a financial relationship, unless a specific statutory or regulatory exception applies. Physical therapy is expressly enumerated as a designated health service. Stark is a strict liability civil statute, meaning no intent to induce referrals is required. The only defenses available are those that fit squarely within an enumerated exception. Physician-owned physical therapy practices rely most commonly on the in-office ancillary services exception, but its application requires careful attention to structural and supervision requirements that vary with the business arrangement. The Civil Monetary Penalties Law, or CMPL, and the OIG exclusion authorities provide additional enforcement tools. Mandatory exclusion applies to certain criminal convictions and patient abuse findings, and permissive exclusion reaches state license revocations, substandard care patterns, and related conduct. All Illinois PT and PTA employers bear an affirmative obligation to screen employees, contractors, and business partners against the OIG list of excluded individuals and entities, known as the LEI, at hire and on a monthly basis thereafter. Contracting with or employing an excluded individual in connection with federal program services creates independent CMPL exposure for the employing organization, regardless of whether the employer knew about the exclusion. The APTA Center for Integrity in Practice and its companion resources on fraud, abuse, and waste definitions provide practitioner-facing guidance on identifying and avoiding these exposures. Now let's move to Section 3, the Illinois Self-Referral Act and Billing Integrity. The Illinois Healthcare Worker Self-Referral Act parallels the federal Stark Law in prohibiting self-referral, but extends its reach beyond Medicare and Medicaid to all third-party payers and to all licensed healthcare workers, including physical therapists, who make referrals for healthcare services. A PT who refers a patient to any healthcare facility or provider in which the PT holds a financial interest, including ownership interests, investment arrangements, or compensation structures, without satisfying a statutory exception, violates the Self-Referral Act and simultaneously triggers the disciplinary ground at Section 17 that expressly makes violations of the Healthcare Worker Self-Referral Act a basis for PT license discipline. That dual exposure, a civil violation of the Self-Referral Act and a licensure ground under the Practice Act, reflects the legislature's judgment that referral integrity is a core component of the professional accountability the Practice Act is designed to enforce. A PTA EJC interpretive guidance treats self-referral violations as fundamental breaches of the fiduciary relationship between practitioner and patient, and IPTA presents self-referral ethics as a component of its statewide continuing education programming. Section 17 independently prohibits fee splitting and kickback arrangements under Ground L, with stated exceptions for legitimate partnerships, professional service corporations, and bona fide employment arrangements. Billing fraud is reached through multiple Section 17 grounds concurrently. Ground A covers material misstatement or fraudulent representation. Ground B covers violation of the Act or rules. Ground H covers departure from minimal practice standards. All three apply to documentation practices that falsify treatment time, provider identity, or service content. Standards 6.1 and 6.2 of the 2026 APTA Code require, respectively, that billing representations be truthful and accurate, and that documentation accurately reflect the provider, nature, and extent of services provided. Documentation reflecting treatment time not actually spent with a patient constitutes simultaneous violations of Standards 6.1 and 6.2 and creates disciplinary exposure under Grounds A, B, and H, in addition to potential FCA liability if the falsified billing was submitted to a federal healthcare program. The APTA Center for Integrity in Practice publishes PT-specific guidance identifying common billing risk areas, with documentation templates and compliance resources that Illinois practitioners should incorporate into their practice compliance programs. Let's shift to Section 4, which addresses emerging issues in contemporary Illinois PT practice, including artificial intelligence, social media, practitioner well-being, and mandatory reporting. These are professional challenges that the 2026 APTA Code, the Illinois Physical Therapy Act, and evolving regulatory guidance are actively addressing. Starting with artificial intelligence tools in clinical practice, AI-assisted documentation, decision support systems, and patient communication platforms present practitioners with a distinctive combination of efficiency benefit and ethical risk. AI documentation tools that generate clinical notes from session data or voice dictation may produce inaccurate content that doesn't reflect the actual clinical encounter. Standard 6.2's requirement that documentation accurately reflect the provider, nature, and extent of services provides no safe harbor for AI-generated inaccuracy. Aspirational 8.A of the 2026 Code calls on practitioners to develop and maintain competence in current and emerging technologies, including AI. This encompasses both the ability to use these tools and the clinical judgment to identify and correct inaccurate outputs before documentation is finalized and submitted for billing or record retention. Patient information processed by any AI platform that constitutes protected health information must be governed by a business associate agreement between the platform provider and the practitioner's covered entity organization and must comply with HIPAA's security rule technical safeguard requirements. Where AI-processed information constitutes a confidential communication under MHD-DCA, the Act's stricter protections control over HIPAA, as addressed in Module 6. Social media professional boundary obligations under the 2026 Code are addressed in aspirational provisions 3.d, 5.b, and 5.c, which collectively ask practitioners to maintain accuracy, avoid exploiting the professional relationship, and be mindful of public trust when communicating through digital platforms. HIPAA's minimum necessary standard prohibits any protected health information from appearing in publicly accessible social media content without specific written patient authorization. This prohibition reaches before and after photographs, case narratives, and any content from which a patient could be identified by implication, even when the patient isn't named, and even when the platform imposes internal privacy restrictions that the PT may assume are adequate. State disciplinary exposure under grounds A and H applies independently of any federal HIPAA enforcement action by the Office for Civil Rights. Practitioner well-being is addressed in aspirational 8.e, which calls on practitioners to reflect on and take action to maintain their own physical, emotional, and mental health, and to seek outside assistance when needed. Aspirational 4.d requires PTs and PTAs to encourage colleagues with physical, psychological, or substance-related impairments to seek assistance. This is a professional obligation that Standard 2.3 operationalizes as the mandatory duty to report to appropriate authorities when, in the practitioner's reasonable judgment, knowledge raises a substantial question as to whether a colleague is unfit to perform their professional responsibilities with competence and safety. The empirical grounding for understanding the connection between workplace ethical climate and practitioner well-being comes from Tammany, O'Connell, Allen, and Brisme's 2019 cross-sectional survey of 3,446 PT clinicians. That study found that organizational culture was the strongest predictor of observed unethical behavior in rehabilitation settings, and that skilled nursing facility, or SNF, settings reported approximately 4 times the frequency of high-frequency unethical behavior compared with all other settings. Standard 6.7 provides the practitioner's ethical exit when organizational arrangements become structurally incompatible with professional integrity. PTs and PTAs shall not knowingly enter into or continue any employment or other arrangements that prevent them from fulfilling their professional and ethical obligations to patients and clients. A supervising PT who knowingly permits an impaired colleague to continue practicing in a setting where the PT holds supervisory or organizational authority assumes independent disciplinary exposure under Ground F, which addresses aiding or assisting another in violations of the Act, in addition to the organizational ethics obligations that the RIPS model's organizational realm framework is designed to address. Mandatory reporting obligations apply uniformly to all Illinois PTs and PTAs across all practice settings following Senate Bill 3833's January 1, 2023 expansion of ANCRA. Physical therapists and physical therapist assistants who have reasonable cause to believe that a child known to them in their professional capacity may be abused or neglected must immediately report to the DCFS Child Abuse Hotline at 1-800-252-2873 and confirm that report in writing within 48 hours. For adults age 60 and older, and for persons age 18 to 59 with disabilities who are unable due to dysfunction to report mistreatment themselves, mandatory reporting is required to the APS hotline at 1-866-800-1409 when the PT or PTA believes the adult cannot self-report. Willful failure to report elder abuse or neglect is grounds for PT discipline under Ground P and constitutes a Class A misdemeanor under the Adult Protective Services Act. The good faith reporter immunity that applies to both ANCRA and the Adult Protective Services Act reflects the legislature's policy judgment that the risk of failing to report, enabling ongoing abuse of a vulnerable person, substantially outweighs the risk of a good faith report that subsequent investigation doesn't substantiate. Physical therapists, through the intimate and repeated physical contact inherent in PT treatment, are frequently positioned to observe indicators of abuse that may escape notice in briefer clinical interactions. Moral sensitivity, the first component of the RIPS individual process, is the cognitive skill that converts a clinical observation into a recognized legal and ethical obligation to report. Finally, 2 additional Illinois statutes impose employment and workplace safety compliance obligations on PT employing healthcare businesses. The Healthcare Worker Background Check Act requires covered healthcare employers to screen prospective employees against criminal history records and prohibits employment of individuals with disqualifying convictions in applicable settings absent a statutory waiver process. The Illinois Healthcare Violence Prevention Act requires covered healthcare facilities to develop and implement written workplace violence prevention plans and reporting systems. PTs and PTAs employed in covered inpatient or residential facilities should confirm their employer's compliance with these obligations. Thank you for completing this course. We will now review the exam questions to solidify your understanding. Question 1. The Physical Therapy Licensing and Disciplinary Board in Illinois is a 7-member body that serves in what capacity to the Secretary of IDFPR? The correct answer is C. Advisory, recommending actions to the Secretary who retains sole final authority rationale. According to the course content, the Physical Therapy Licensing and Disciplinary Board is a 7-member advisory body. The board acts in an advisory capacity and does not issue binding orders. The Secretary of IDFPR retains sole authority to render final licensure and disciplinary determinations. Board members participate in reviewing licensure applications, advising on disciplinary matters, and recommending policy positions, but all final decisions rest with the Secretary. Question 2. Which of the following is a required prerequisite before a PT or PTA may perform dry needling in Illinois? The correct answer is A. Completion of at least 54 practicum hours covering intramuscular manual therapy technique rationale. The 5-element prerequisite sequence for dry needling requires at least 54 practicum hours covering intramuscular manual therapy technique, indications, contraindications, documentation, adverse effect management, practical psychomotor competency, and the Occupational Safety and Health Administration bloodborne pathogens standard. The didactic requirement is 30 hours, not 40. The competency exam is division approved, not nationally standardized, and the required patient sessions number 200, not 100. Question 3. Under Illinois direct access provisions, a PT must refer a patient who does not demonstrate measurable or functional improvement after which of the following thresholds? The correct answer is D. 10 visits or 15 business days, whichever occurs first. Rationale. Section 1.2 of the Illinois Physical Therapy Act imposes an affirmative re-referral obligation when the patient does not demonstrate measurable or functional improvement after 10 visits or 15 business days, whichever occurs first, and does not demonstrate continued improvement thereafter. The PT must then refer the patient to a healthcare professional. Question 4. When a PTA performs dry needling in Illinois, the supervising PT must provide which level of supervision? The correct answer is B. Direct line of sight supervision by a PT who has completed the same prerequisite training rationale. For a PTA performing dry needling or intramuscular manual therapy, the administrative code requires direct line of sight supervision by a PT who has independently satisfied all 5 prerequisite training requirements. The supervising PT must be physically present in the room and visually monitoring the PTA's technique throughout the procedure. This standard is more restrictive than the general supervision that governs most other PTA clinical activities. Question 5. Under the current Illinois administrative rule effective April 2024, what is the maximum percentage of total CE hours that may be satisfied through self-study formats? The correct answer is C. 75% rationale. Effective April 5, 2024, IDFPR amended Section 1340.61 to raise the self-study cap from 50% to 75% of the total continuing education requirement. Under the current rule, a PT may satisfy up to 30 of the required 40 hours through self-study, and a PTA may satisfy up to 15 of the required 20 hours through self-study. Question 6. In the RIPS model of ethical decision-making, which structural component describes the contextual level at which the ethical decision occurs? The correct answer is A. The realm rationale. The realm is the first structural component of the RIPS model and describes the contextual level at which the ethical decision occurs. There are 3 realms. The individual realm encompasses the direct practitioner-patient relationship. The organizational or institutional realm encompasses workplace structures and policies. And the societal realm encompasses healthcare policy, resource allocation, and social justice. Question 7. A physical therapist at an outpatient clinic determines that a patient's documented functional limitations require continued intervention, but facility administration has denied the request citing productivity benchmarks. The therapist recognizes the appropriate course of action but cannot carry it out due to the institutional constraint. In the RIPS model, this scenario best illustrates which type of ethical situation? The correct answer is D, ethical distress rationale. An ethical distress situation is one in which the practitioner recognizes the right course of action but faces institutional, structural, or relational barriers that impede or prevent carrying it out. In this scenario, the therapist knows the patient needs continued intervention but the facility's productivity policy prevents it. This is distinct from an ethical dilemma, which presents two mutually exclusive courses each supported by legitimate ethical reasoning, and ethical temptation, which presents a clear right versus wrong choice where the wrong course offers personal advantage, and ethical silence, where values are being violated but no one is raising the challenge. Question 8. The 2026 APTA Code of Ethics for the physical therapy profession is historically significant because it replaced which of the following? The correct answer is B, the separate Code of Ethics for the physical therapist and the Standards of Ethical Conduct for the physical therapist assistant rationale. The 2026 APTA, a Code of Ethics for the physical therapy profession, replaced two previously separate instruments: the Code of Ethics for the physical therapist and the Standards of Ethical Conduct for the physical therapist assistant. In their place, it established a single, unified code applicable to both PTs and PTAs, reflecting the profession's recognition that physical therapists and physical therapist assistants share a common ethical foundation. Question 9. A physical therapy clinic owner becomes aware that the billing department is routinely applying incorrect CPT codes to group therapy sessions but takes no steps to investigate or correct the practice. Under the Federal False Claims Act, the statutory definition of knowingly submitting a false claim includes which of the following? The correct answer is A, actual knowledge, deliberate ignorance, or reckless disregard of truth or falsity rationale. The False Claims Act defines knowing to encompass actual knowledge, deliberate ignorance of the truth or falsity of information, and reckless disregard of the truth or falsity. No specific intent to defraud is required. This broad definition means that a clinic owner who becomes aware of incorrect billing practices but takes no steps to investigate or correct them cannot avoid liability by claiming ignorance when the circumstances would put a reasonable person on notice that claims were false. Question 10. Under the Illinois Healthcare Worker Self-Referral Act, a violation by a PT simultaneously triggers which additional consequence? The correct answer is C, a disciplinary ground under Section 17 of the Illinois Physical Therapy Act rationale. A PT who violates the Illinois Healthcare Worker Self-Referral Act simultaneously triggers the disciplinary ground at Section 17 of the Illinois Physical Therapy Act, which expressly makes violations of the Self-Referral Act a basis for PT license discipline. This dual exposure reflects the legislature's judgment that referral integrity is a core component of the professional accountability the Practice Act is designed to enforce. That concludes our exam review. Thank you for completing this course on ethics and jurisprudence in Illinois physical therapy practice. We wish you the very best in your continued professional development.